All right, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, January 30th, and we have 12 bills on the docket. We're going to start off with Senate Bill 199, which is Senator Waldstreicher. We're then going to go to Senate Bill 46, Senate Bill 105, Senate Bill 141, 159, 171, 125, 206, 147, 57, 19, and we'll end with 162. There may be some variability in that, just based on some of the House cross files and some of the witnesses having to get from here to there and vice versa. So just be flexible with that. But we will start off with Senator Waldstreicher with Senate Bill 199. Are you okay with that? Okay, excellent. So it looks like we're already pulling the audible. We're gonna go then. Is Senator Augustine here? He is not. Okay, then we're gonna go with Senate Bill 206. I am here. That's my bill, so I know we can go with that one. All right. This should be very quick, but I'm gonna go with Senate Bill 206. All right. Good afternoon, members of the committee. Senator Smith here to testify on behalf of Senate Bill 206. Now, obviously, we in 2000, actually the last two sessions, we passed climate change legislation aimed. No, thanks, I'm good. Thank you. I appreciate that. Aimed at reducing our greenhouse gas emissions by 2031. That's an aggressive goal, and we want to use every tool in the toolbox possible to meet that goal. The bill that you have before you today is fairly simple, and we've done these from time to time, and I know Senator West has had a number of these over the course of the years, which is essentially for a condo association or board or committee for that threshold to be lowered in order to make a change. Like, so for instance, in this legislation, we're lowering the threshold from 2/3, 66% of that body to 51%, a simple majority, for them to be able to grant an easement to create solar panels, to create a mechanism for solar energy. And that's essentially what the bill does. And if you look at this part of the statute, all of the procedural mechanisms for calling the meeting, for recording the meeting, for challenging the decision are all still laid forth and still remain in the statute. This bill simply just lowers the threshold for this, for the ability to have that clean energy from 66% to 51%. You'll also notice that there are some just technical changes in the bill. It's fairly straightforward. It's a 4-page bill. You'll see that like on line 2, on page 2, line 23, small technical changes like 2/3 is now in words and hyphenated as opposed to the numbers. Those are just technical changes, non-substantive. And with that, Mr. Vice Chair or whomever, I will, that concludes my testimony. You're going to hear from some witnesses that will speak to the importance of removing this barrier to ensure that we have, the condos around our state have access to clean energy and renewable energy.
Would you like to take questions now, or would you like to wait until the end of your panel?
We can wait till the end. I'll stay up here. And,
okay.
I'll be here for questions.
Thank you.
Whenever you're ready.
All right, good afternoon. My name is Stephen Morrell. I'm the CEO.
Sandy.
Good to go?
Yeah, good to go.
All right, thank you. Sorry about that. Good afternoon. My name is Stephen Morrell. I'm the CEO of the Montgomery County Green Bank. The Green Bank is a publicly chartered nonprofit financial intermediary dedicated to accelerating clean energy and climate resilience investments. We catalyze private sector investment through credit enhancements, co-lending, participations, syndications, and secondary markets. Over the last 3 years, our project investments have grown exponentially. We have been fortunate to work across a variety of sectors. Distributed solar represents almost 70% of our portfolio. This is an important sector for many reasons. including one, the strongest efficacy rate in our portfolio for GHG mitigation per dollar spent, and two, due to a strong alignment with multifamily properties to maintain affordability. However, we have only ever served one condo association with power purchase agreement or PPA financing due to challenges in the condo law. Montgomery County, Maryland has over 300 condos representing over 40,000 units. The condo market is traditionally underserved in the solar industry. Project sizes are relatively small and slow to process. Furthermore, volunteer boards struggle with competing demands. PPAs have a particular appeal to condo boards and nonprofits broadly, given that a developer constructs, holds, and operates the assets. The end user purchases power, typically at a discount, with no upfront capital outlay requirements and minimal ongoing maintenance. The benefits of PPAs are currently overshadowed by the burden of compliance with the condo law, originally designed for different types of property alterations. We believe it is important to align PPA approvals with traditional association leaseholds. Thank you.
Hello, thank you very much for having me. First, I would like to mention that I'm an electric regulatory attorney at the U.S. FERC, and any views expressed herein are my own solely, not of the United States. I'm speaking to you as a resident and board member of Chevy Chase Crest, a condominium community located in Montgomery County at DC's North Boundary Stone, and as a supporter of Senate Bill 206. Our community has been working for over 2 years to install what will eventually be an approximately 200 kilowatt rooftop solar facility set to provide income for our community account and utility bill relief for our fellow neighbors. This journey has lasted 2 years thus far, primarily because at the 11th hour, our condominium attorney informed us that in order to enter into a solar leasing agreement with any of the local developers, the Maryland Condominium Act requires us to gain 66 2/3 approval from all condominium co-owners and each of their mortgagees. This is a problem for 2 reasons. First, because we only have about a 50% owner occupancy rate for our 80 homes and see single-digit turnout for our board meetings every month. And second, because we do not have the resources to reach out to and convince upwards of 80 different banks not to oppose our project. We are coming before you seeking that this law be amended because we have seen tremendous support from all of our neighbors who have weighed in on this issue and want to make sure other communities can avoid this barrier to accessing more affordable energy. As we push to achieve our state's clean energy future, it is paramount that we stamp out any and all red tape blocking citizens from participating. Amending the Maryland Condominium Act in accordance with Senate Bill 206 represents a meaningful step toward that goal. So I urge this body to issue a favorable report on Senate Bill 206, and thank you very much for your time and stand ready to address any questions or concerns you may have. Thank you.
Thank you all for being here today. I appreciate your testimony. I like when we get some of these bills that traditionally go to finance or otherwise deal with issues we don't always deal with. So any questions for this sponsor or for our 2 witnesses? All right. I think that will conclude the hearing for Senate Bill 206. Thank you for your testimony here today.
Thank you very much.
And there's no opposition to that bill. The next bill will be mine, Senate Bill 199, and then Senate Bill 46. All right, Mr. Chairman, thank you for the accommodation and swapping out. Mr. Chairman, members of the committee, the next 2 bills will move fast. We had hearings on each bill last year when they came over from the House. Neither are controversial, so I want to be respectful of everyone's time here. The first bill is Senate Bill 199. Senate Bill 199 deals with affordable land trusts. An affordable land trust is a nonprofit or governmental unit that specifically purchases land in order to build or redevelop affordable housing. Traditionally, land trusts purchase single-family properties and either build new affordable housing on that lot or redevelop a vacant property. In Baltimore City in District 46, an affordable land trust instead sought to use trust assets to purchase and redevelop multifamily housing. The law was unclear as to whether they could do so. Their lawyers figured out a circuitous way by which to possibly conform to current law, but doing so raised prices in a way that then made the property unaffordable. Instead, the best path is to simply add affordable land trusts as eligible to establish condominium regimes. This bill does just that, and I ask for a favorable report. Whoever wants to go next.
I think Claudia's.
It may be easier.
Good afternoon. My name is Claudia Wilson. Oh, okay.
Thank you.
Good afternoon. My name is Claudia Wilson Randall. I'm the Executive Director of the Community Development Network of Maryland. And today I'm here to speak in favor of Senate Bill 199. You have my written testimony. I just want to focus on one aspect of the community land trusts. There's an urgent need for housing and more particularly affordable housing in Maryland. And we need to have as many tools as possible in order to address this need. And community land trusts offer an excellent opportunity to create more housing in Maryland. So it's important, this technical amendment, it did pass the House last year, is really critical in us having another tool for affordable housing development in the state of Maryland. And I ask your favorable report for Senate Bill 199. Thank you so much.
Chairman Smith and the other members of the Judicial Proceedings Committee. My name is Dan Ehrenberg. I'm a board member of the Community Development Network of Maryland, a resident of Kent County, Maryland, and also an affordable housing attorney. I am speaking in favor of Senate Bill 199. I think my colleagues, the Senator and Claudia, have spoken about this bill. So let me just add a couple of technical points to it. Affordable housing land trusts are creating affordable housing that will be affordable in perpetuity for low and moderate income families. Primarily, it is single family properties where the land trust owns the land and the homeowner owns the home, and the way that it stays perpetually affordable is that the housing trust is able to, through the land, enter into a affordable housing land trust agreement, which is similar to a ground lease. As we all know, ground leases are disfavored in Maryland. So when the Affordable Housing Land Trust Act was passed in 2010, they were exempted from the ground lease provisions. However, what they didn't do, and it was probably an oversight, is that they didn't exempt affordable housing land trusts from the requirement in the Residential Condominium Act that you cannot have a condominium with a leasehold estate. Now, a leasehold estate is another word for ground lease, but the attorneys who viewed this had some questions as to whether leasehold estate was the same as a ground lease. So what this bill does is it basically exempts affordable housing land trusts from having to have the restriction of a leasehold estate. So they can then create, build, develop condominiums for affordable housing families and keep those homes affordable in perpetuity. Thank you.
Great. Chairman Smith and the esteemed members of the Senate Judicial Proceedings Committee, my name is Crystal Okafor. I am the Director of Policy and Planning at Share Baltimore, which is Baltimore's Community Land Trust Network, CLT. Share Baltimore is pleased to support this bill, which, once enacted, will provide CLTs the authority to develop condominiums. CLTs are nonprofit housing developers with a focus on inclusive growth. We are working apace to rehabilitate and subsidize housing in the Baltimore neighborhoods of Bel Air Edison, Curtis Bay, McElderry Park, Highlandtown, and Westport. The passage of this bill will allow us to further promote housing security for low and moderate income households in Charm City. The hallmarks of our model, the CLT model, are permanent affordability and community stewardship. To achieve permanent affordability, CLTs acquire land, splitting title to the homes they develop and title to the land on which the home sits. Once CLTs have rehabilitated a property, they deed the home and ground lease the underlying land to a low or moderate income buyer. The ground lease is coupled with subsidies, resale restrictions, and income eligibility limits that ensure that the home remains affordable to families in need in perpetuity. This bill is required because of CLT's reliance on leased land. Under Maryland law, condominium regimes may generally not be established on leased land. Doing so might destabilize the homeowner's tenure. However, since the CLT model is premised on permanent affordability that is documented and preserved in a 99-year renewable ground lease, CLT's creation of affordable condominiums is inherently stable. That's why CLTs merit an exemption to this rule. I urge you to pass this bill so that we at Share Baltimore, the Community Land Trust Network, may continue to own and develop land for the benefit of the community. Thank you so much.
Thank you all very much. Questions from the committee? All right, seeing none, that will conclude the hearing for Senate Bill 199. Thank you, Senator Walstreicher and panel. Do you want to go on to Senate Bill 46, Senator?
If that's your preference.
Excellent, yeah. Let's,
Thank you, Mr. Chairman. If you're here for Senate Bill 46, please come on up. This will be brief, Mr. Chairman. So, as many of you know, every transaction of residential property in Maryland requires an asbestos disclosure. Every transaction, that is, except for condominium purchases. This bill simply closes that gap. It requires an asbestos disclosure for condominiums. Last year, as the bill worked its way through the House, our friends, the realtors, requested a clarifying amendment. That amendment is already in the bill, so we're good to go on that. This year, our friends MMHA have requested some further clarification. I support the MMHA amendment, as does the cross-filing delegate. And I will request that amendment's drafting so we have it if we decide to vote on this bill. With that, Mr. Chairman, I ask for a favorable report.
Good afternoon, Chair Smith and members of the committee. My name is Jose Coronado Flores. I'm CASA's policy analyst. CASA is Maryland's largest services and advocacy organization for the immigrant and working class community. We're here in support of SB 46 because our members are overwhelmingly renters. This doesn't mean that they just rent in apartment complexes nor single family homes, but they also sublet condominiums. And we work a lot with the issue of housing conditions, asbestos being one of them. This is important legislation that will make sure that when a renter goes and sublets in a condo, they know they can be assured that asbestos has been treated and there isn't any unknown or untreated asbestos in the unit. This is particularly important because a single fiber of asbestos lodged in one's lungs can lead to long-term health issues and immediately can cause fatigue levels and drowsiness. With all of this, we're working towards a Maryland where everybody has safe and healthy housing, and this bill would contribute to that. With that, we urge a favorable report. Thank you.
Good afternoon, Mr. Chairman, members of the committee. Steve Sakamoto Wengel on behalf of the Consumer Protection Division of the Attorney General's Office, here in support of Senate Bill 46. Part of the Consumer Protection Division's role is ensuring that people have full knowledge before they enter into transactions, and especially when you're buying real property such as a condominium or renting a condominium unit. It's important to know whether or not there are hazards in that particular unit. And asbestos is a well-known hazard. So we believe that the disclosure is important And if you're buying a condominium unit, some of that information might be in the realm of the council of unit owners because it might affect a common area or areas that were treated before the individual bought that particular unit. So we believe this disclosure bill is very important, would urge a favorable report. Thank you.
That's your full panel, correct?
Yep.
Any questions? All right, thank you very much. Mr. Castelli?
Thank you, Mr. Chair, members of the committee, Bill Castelli on behalf of the Maryland Realtors. We are in support of the legislation. And conceptually, we haven't seen the language, but would be in support of the MMHA amendment. So thank you.
Thank you very much. Any questions? All right. Mr. Wiggins.
Good afternoon, Mr. Chair, members of the committee. Good to see everybody again. Here today on behalf of CAI Maryland. I know everybody's so used to seeing me in here for MMHA that was probably presumed, but actually for one of my condo clients. And our amendment is pretty straightforward. Just on page 2, line 31, and page 4, line 34 of the bill, where it references actual knowledge of the Council of Unit Owners, we would instead request the amendment provide more of a blanket notice similar to how we do lead paint for rental units. And so if the property was built before August 25th, 1989, the seller would provide a statement to the buyer that the asbestos may be on the property. I didn't pick that date out of a hat, I promise. According to the EPA website, it's when they ban new use of asbestos and new asbestos products from entering the marketplace after August 25th, 1989. So thank you, Mr. Chair.
Thank you. Any questions? All right, that concludes the hearing for Senate Bill 46. Next, we'll have Senator Ellis come up for Senate Bill 105.
I can pull up your PowerPoint.
Okay, great.
You're welcome. There you go. You can just hit. There you go. Just hit that button and we're good.
Good afternoon, Chair Sidnor and members of the JPR Committee. I'm Senator Arthur Ellis from District 28, Charles County, here to present Senate Bill 105, deal with the burial of the sites of the enslaved persons and the Protection Act. So a couple months ago, I was reading the Washington Post, and they have a deep read article on this individual who tried to gain access to the burial sites of her deceased enslaved ancestors in Howard County. And the article talked about how the former plantation had a brand new owner, and the owner said, "No, I will not allow you to visit the burial site." And the featured person in this article is here, and you'll hear from her a little later. And I said, "Oh, that bothered me all for 24 hours." And then I remembered I was a Maryland senator, and I can put a bill to kind of fix that. So I wasn't bothered so much, but I went to work and drafting up legislation to create a continual access to these many sites that exist in Maryland that are now, most are privately owned. But a lot of the ancestors of the enslaved, they know where these sites are, and they try to have access to the burial sites. So let me see. Second. Clean up the screen. The purpose of this bill is to require owners of these former plantations to identify and allow visitation to certain burial sites of the enslaved persons under specific circumstances. So this bill will not create unfettered access to everyone to private property. The people who want to visit these sites have to have an interest, relatives, and they will be able to schedule say a weekend, 1 weekend per month, on certain significant federal holidays like Juneteenth or Dr. King's birthday to visit these sites. And so the public will not just have free access to these locations that are on private property. And additionally, this bill prohibit the construction of any structure on these sites, and also establish the Office of Burial Sites of the Maryland Enslaved and fund that particular office. So I'll tell this part of the story of Miss Stephanie Gilbert, who's right here. Her great-grandfather, Oliver Gilbert, who was an enslaved person, previously on the Richland farm, the plantation her family once worked on and is now buried on, chose to sell this property and deny access to Miss Stephanie here to visit her ancestors' remains. This concern unfortunately became a reality. The new owners of it's called Richland Farm in Howard County said, no, you cannot visit, and there will be no more discussion, and the law does not create any pathway to address this issue. Therefore, Senate Bill 105 creates a person of interest that will be able to visit these burial sites without dispute from the current owners. The person of interest includes people who are related by blood or interest, is a domestic partner, has cultural affiliation, has an interest in the burial site as recognized by the state's attorney's office, or has learned through oral tradition the person's relation to an enslaved person interred in the burial site. The Office of Burial Sites of the Maryland Enslaved, which will be a new office established this bill, will be tasked with identifying, studying, and preserving the burial sites of enslaved persons on the former plantations within the state of Maryland. This bill will ensure descendants of the past enslaved persons can still feel connected to their ancestors' rich history. I must want to add that most enslaved persons were buried on the same land they were once enslaved on. There were no separate cemeteries for the enslaved. And their bodies, their bones are still there. And would you believe they're still considered property? They're still owned by the people who are who have title to that land. So technically, the former enslaved in Maryland, their bones are still in slavery. They're still privately owned. And that will send a chill through my bones to think that all these Marylanders, their ancestors are still owned by, a lot of times, the owners of the former plantation. So this bill creates an opportunity for us to fix that while respecting property rights and respecting all Marylanders for the history that we inherited. There's some historical facts. In addition to Ms. Stephanie here, there's the story of London Gould on the eastern shore in Anne Arundel County, passed away in 1854. We have pictures, documentation of the burial site, Gould Town Cemetery. And this is an example of a documented burial site here in Maryland. The slave burial grounds were sold a lot of times to African Americans, but they could not maintain these lands. A lot of them, there were gullies or just ungovernable, undesirable land, and they go on registered and not really controlled, but they're often connected still to Marylanders. And a citation to a lot of the research And in interest of time, I will end my presentation there and ask for a favorable report on Senate Bill 105.
Excellent. Thank you very much, Mr. Senator Ellis. We'll next hear from your witness.
I'm sorry, Mr. Chairman.
Oh, thank you very much for your presentation. We'll hear from your witness if you like.
Okay, yeah.
Yeah.
Thank you.
Thank you very much. This is a fantastic presentation.
Good afternoon, Stephanie Gilbert, representing Senate Bill 105 and the descendant community of the enslaved from Maryland. When the man who would become Maryland's 45th governor, Edwin Warfield, wrote to my second great-grandfather in 1896, he interviewed his family about their history of enslaving mine, citing at least 5 generations of them, enslaved at his family plantation in Clarksville. As members of the governor's enslaving family had died on the property, each of them were buried on site in an honorable family plot at a most prominent peak, visible today from Shepherd Lane in Clarksville. The Watkins family plot is on property owned by the private homeowner, who is proud to acknowledge that her immigrant family wasn't even here during the American Revolution. Yet she yields in remembrance and honor of those Americans who commit to deserving remembrance. Yet just adjacent to this prominent memorial is the well-maintained headquarters of both the domestic and agricultural life on Walnut Grove and Richland Farm. Here, oral history tells us that the enslaved people were buried near the slave quarters, which we know were located not far from the back of the home. With legislation in place, such as the proposed Senate Bill 105, property owners would participate in a satisfying and healing, simple form of reparations, offering a balm to those descendant communities who choose to honor their ancestors through the ancient and widely acceptable ritual of memorial visitation. We, the descendants of Oliver Gilbert, and in support of all formerly enslaved in Maryland, ask that due consideration be given to stabilizing a fracture in the foundation on which we, Americans, collectively build our future. Allow us, the descendants of the enslaved, all of us, to honor our past with the reverence and dignity that is afforded our American counterparts who emigrated by choice and not by force. Let's close the gap on the current day American experience and start with a simple yet meaningful opportunity. Thank you.
Thank you very much, Ms. Gilbert. Questions from the committee? We have one. We have 2, 3. Senator West was first, then Senator Sidnor, then Senator McKay.
Thank you, Mr. Chair. So I am a member of the Maryland Historical Trust by virtue of an appointment from the Senate President. And during my meetings at the Maryland Historical Trust, I can never remember discussing plantations. Your bill says the word is defined as a large agricultural estate or farm as designated by the Maryland Historical Trust. Are you sure that the Maryland Historical Trust has designated plantations?
Yeah, so that's a very technical question and I can't answer it directly. And I would have to get back to you with that answer.
All I'm saying is I can never remember the term plantations being discussed as being designated by the Maryland Historical Trust. And the whole bill is premised on the fact that these plantations are designated by the MHT. So that's my first question. 2 years ago, the Maryland Historical Trust issued a 79-page report entitled Historic African American Cemeteries. You've read that?
No, I haven't.
You haven't?
No.
Okay. Well, let's see.
Have you? Can you tell me what it talks about?
Yeah, it talks it talks about the whole idea of this bill. It talks about recognizing African American cemeteries, identifying them, and preserving them.
Okay. So there's a difference between the African American cemeteries, they're there, and the burial grounds that are not recognized by the state. This bill would recognize those burial grounds as a cemetery. Right now, there's a gray area where the law says landowners may grant access. And if they say no, like in the case of Ms. Stephanie here, then it's over. So this bill creates new rights and recognize these burial grounds, which are unofficial cemeteries.
I understand.
as cemeteries. So it's a brand new designation
Well, the
of
report,
these,
report goes into that, talks about unmarked cemeteries and trying to locate them and using radar to
Yes,
penetrate the
ground
ground,
penetrating
find
radar,
out where
yeah.
the bones are, et cetera. It's, as I say, it's 79 pages and it's pretty extensive. So, but it does say in the report, ownership of family cemeteries can be difficult to discern due to the sale and or subdivision of property. So the plantation, is it not correct that the plantations that originally existed over the course of centuries could have been subdivided and now may not be a plantation anymore, but may consist of subdivisions and other properties that are owned by individual owners on what used to be the plantation?
and that's the gist of this bill, to recognize those burial grounds and declare them as cemeteries and protected from people putting structures on them, parking lots, new building, subdivide. If they subdivide, they can't build on that particular area recognized as a cemetery. And this bill would grant that recognition.
Right. So the report, which is really quite sensitively written, the recommendation 1.1.1 is encourage property owners to allow access to burial sites. But this bill doesn't just encourage property owners. This bill requires property owners.
That is correct, Senator.
Okay. So
because that encouragement haven't worked in this case, concrete case, people have the right to say, no, you just can't visit, and that's it.
Gotcha. So, but this bill requires an owner of land that encompasses any part of a former foundation to allow people to come onto his property periodically, even though he might not want them on his property, correct?
Well, it's not allow people, it's allowed people of interest.
Yeah,
so descendants and researchers to come and to at planned time. So this bill doesn't allow unfettered access to the public to private lands. We're very conscious of that. And so this is a narrow carve out. The bill suggests maybe one weekend a month. And of course, these holidays are very significant to African Americans, like Dr. King's annual birthday or the Juneteenth, which is celebrated as a National Freedom Day for African Americans.
I know, I get all that. But I don't see in the bill where the people who are permitted to come on to the property are identified. It just says that the owner shall allow visitation to any burial site where enslaved persons are interred by a person in interest.
Yes, a person of interest, correct.
Okay.
So, by oral history, they're related, or they're by blood, or, you know, because it's amazing. So many African Americans now are interested in DNA and lineage. And so lots now of us, Marylanders, are tracing our ancestry back to these plantations of our ancestors' enslavement. And it's possible, records exist. In the testimony I presented, it showed a document showing where this individuals were interred in Queen Anne's County, close to Centerville. So we have documentation all over the place. And as more African Americans are interested in this topic, we are finding that documentation and we can identify exactly where our ancestors were enslaved and helped build America to the tune of, in 1840, 80% of the GDP, the gross domestic product of this country, all the goods and services produced were produced by the enslaved. 80%.
Yes.
It's a tremendous amount of contribution these enslaved people made to the country we have as the most powerful country in the world right now. And so the documentations are there, and insurance records, and government records, and sales records, commercial records, and courthouses. The documentation is there, and it's bubbling up, and more and more folks are stuck with not being able to visit the site for their ancestors' remains.
Got it. Does the bill make any provision for compensating people who own this property these days and have homes, maybe backyards on the property, to compensate them for allowing people who they don't know to come onto their property monthly and visit their property?
So you're referring to like an admission fee? So the reason I said earlier, I anticipated that question. So remember I said 80% of the GDP back then was produced by the enslaved. These people paid enough. They should not pay anything to visit the ancestors. As a matter of fact, they should be paid transportation costs, but I didn't put that in this bill.
All right, and then finally, are you aware that the Catholic Conference has suggested several amendments to your bill? Are you
Are they
willing to- are you
in
willing
support
to
with
accept the-
amendments?
Excuse me?
Are they in support with amendments? I didn't see that document. I think it's just.
Favorable with
Oh,
amendments.
favorable amendments.
Yeah.
Oh, no, I will, that's really good. Thank you for letting me know. Yeah, thank you for the Catholic Conference for that. And so if you could speak to that with me now, or you want to send that to me and I will look at it, but I'm glad they're favorable.
Okay, I downloaded it from my computer. I'm sure it's available at this point. So
Okay,
I suggest you take a look and see whether you can accept their amendment.
okay, I sure will, Senator. Thank you.
Thank you.
I'm sorry, Mr. Chairman. Okay, thank you so much.
Thank you, Mr. Chairman. Thank you, Senator, for bringing this bill. Are you familiar with the Coalition to Protect Maryland burial sites?
No, I'm not.
So that was established in 1992. And there's actually there's reference here that actually does exactly what you're talking about, in that it determines that, first of all, we have cemeteries, but then we also have burial sites. And so I think if you get a hold of them, you may be able to find an alliance there.
Okay.
I'm a member of the Cumberland Historic Cemetery Organization, which is a member of the coalition. And Maryland actually has one of the best burial sites protection in the state of Maryland. Now, it doesn't go as far as your bill about the $2.5 million what's the right word? Appropriation, $2.5 million. They've never had that type of money to deal with.
Okay.
But it does talk about having the right to be able to go on to a particular property that you've been able to determine is your ancestors there. And we've been fighting that in Allegheny County for years. Matter of fact, we were able to, back in, not before I was born, but before I got involved, let's just say, to be able to recognize African-American burial sites in Allegheny County. And matter of fact, we actually set up the first northern monuments to African-American veterans in the Civil War. So be glad to put you in touch with those people.
Yeah, thank you, Senator. And I appreciate the work you've done in Allegheny County to move this needle forward. And I must say, I wish all of Maryland was like Allegheny County doing that. But we have, 23 jurisdictions. And, like even recently, last year in Howard County, the answer was no. So the question is, as legislators, we can move the bar and say to everyone, grant reasonable access. So this battle doesn't have to be fight family, by county, by town, all over Maryland. And, it's exhausting. And we want our families to move on to other things, right? To take care of their children and to be able to spend time taking them to a ball game instead of having to come here and testify and have to go through a coalition, go to that commission, go here, go there, go, it's like, we're Maryland, we're better than that in 2024. And so this bill aims to move the needle forward and recognizing the work that's been done through that coalition and others, but to create that right and not, we're always still begging permission for the most basic human needs of connecting with our ancestors. So I appreciate that, and please send me that if you can.
So I was going to say, I think you already have that ability in the state of Maryland to do that. It's already codified it in law. So
I'm sorry, to do what, Senator? Ability to do what?
To actually visit burial sites of ancestors. You already have the right to do that.
Well, if you look in the fiscal note on your computer, it says current law says it's probably may grant that right. And it says specifically in the fiscal note, this bill says shall grant that right. So right now, we're just open to the kindness of owners of former plantations.
Okay, well, I'll get with the bill drafter. So
Sure.
This has been going on for 20+ years.
Yeah.
It's not new. So thank you, sir.
Okay, you're welcome, sir.
Thank you. I'm losing my mind. Is it out? Senator Ellis, thank you for bringing this bill and doing the presentation. Much appreciated. You know, I think it's so important what we're talking about, but I want to just mention to you, there are Black and white people buried all over the state of Maryland because we didn't used to have cemeteries, and farmers would bury people out on their farm. And I say this because, believe it or not, I have some relatives out in Frederick that had a farm. And way back in the woods, there are these very old graves, right? And I myself have tried to look into how much it would cost to protect it, to move the body. So it is an issue that affects many people before we got into the modern situation of burying people in cemeteries, and or rural people in particular didn't have local churches. So I think it might be a bill that might be good to be expanded on, but I won't hijack it for that purpose. But here's what I wanted to ask you about. The only thing that kind of struck me as odd, and maybe we could compromise or figure out better language, was on page 3, line 13 and 14, the owner may not construct any object on the burial site. Now, I thought the law was that if a landowner is aware that there are human remains, they'll be aware of it, that I didn't think you could build on top of that. Number one, and you can, let me know later. We don't have to delay this. And I thought that a landowner might be allowed to have some flexibility here if they say this: can't construct anything unless arrangements are made to remove the human remains, and bury them elsewhere, because I know this happens a lot, right? There are places all over this country. I know it happens a lot in New York City just because, they make the press. And you can't, Manhattan, very hard to say we're not going to build over something. And it's such an old city in many ways, for at least in the United States. So there's a lot of underground burials that are discovered during construction. Bones are found. Everyone stops, very respectful. People come in carefully, then remove the remains and rebury. And depending on what people want, you could maybe do some genetic testing, determine the lineage of the bones. And I do want to just say, and so that's a question. And the last thing I want to say is this becomes even more of interest to a broader group of people, because DNA and those tests we're all doing, that Ancestry.com is helping people, even people that have been very ripped away from their past, or at least able to find some relatives in the past through this, progress with science and DNA. But so I'm so glad we're talking about it. But again, I'm trying to think about how we wouldn't have a hard stop. You can't construct, but I think it might be unless respectful arrangements are made, because I believe that is the law, generally speaking. And I say that because you may break up. I hate to see farms and plantations broken up, but they get broken up. You've got to go on with housing. You need urban, whatever you need. And what you've got to do in that instance is you can't have, the world circle around a small area. You respectfully remove and rebury the bone. Does that make sense to you? Would you be open to that kind of thing, which I think is maybe the better way to go?
Thank you, Senator James. That's really a lot of thoughtful, deep questions. And so I really appreciate that. All the questions are thoughtful and deep, members. But I don't want to make them think I'm treating you special, but But the thing is, in Finance Committee, I serve on the Finance Committee. Last week, we heard a departmental bill about the moving of remains and the transit. It's about a transit permit to keep track of those remains. So the problem right now is when you move a lot of these remains, there are no regulations, no rules, no paperwork required. So that bill, which we passed in Finance, and I think hit the Senate floor today, requires a permit to be granted and to be filed in, I think, the state's attorney's office on keeping track when you move those remains. So moving the remains is possible in laws right now, but it's very much unregulated. And they showed pictures. This is the Labor Department put the bill, a departmental bill, of people moving remains unmarked, put all of them in a mass grave and just leaving it on the side of a property. So this bill, which we passed in Finance and was on second reader on the floor today, will aim to correct that. So it's possible to move those those burials.
Sir, just to clarify, I'm glad you're very familiar because we should, some states are further along than we are, obviously, but we are, 100 years, 1,000 years from now, we just keep building. So we have to do this no matter what. But what I'm saying is we would probably then have to modify your bill language to say the owner may not construct any object on the burial site unless, assuming this bill passes, they have to get the appropriate permits or whatever the process will be. Because what your bill does, which I don't think a lot of us could support, would be you just can't do anything there. I don't think we want to go that far. I think we want to say if a burial is there, a burial site's there, that we find some remains, the landowner would then have to comply with the new process of getting the permit and moving the remains consistent with the law. I think that's what you want to do anyway, but I just think what you didn't want to do is have them just come in and be cavalier, cruel, and just destroy something. And I agree with you.
And so I think current law allows for the movement of remains. That's why we needed that clarification on the bill that we passed through Finance on moving remains. So the current law allows that. And it has to be done in a dignified, traceable manner. So current law allows remains to be moved for construction and whatever. That's not a conflict. So I don't think we need a new legislation to allow that.
But you would not object if it needed that modification just because of the language. But you're saying existing law has to be blended with this language here.
Sure.
And I just want to double check that.
Because this language is kind of inserted into existing language. And so a lot of those protections are already there in law.
Okay.
And earlier points you made, the question you asked about, so many other rural, whether it's graves or white those are issues that are out there. And the administration reached out to me for a companion bill, which will allow it to take care of those particular cemeteries. And that is, I don't think we have an LR number of that yet, but it's coming up in a few days. So it's we've spent a lot of time working with the administration, working with the advocates. I have 2 advocates here who've worked for years in this area. They try to sign up, but the system kind of didn't allow them to kind of get in to testify, but they've working on this for many years, working with the African American Museum, and they are really in this space. And this is an opportunity now for us to do something to really move the needle forward, not just for the burial grounds for the formerly enslaved, but for all these properties. And so that's coming up to address your concerns in another bill.
Good.
And I don't think you want to hear about that bill right now, Mr. Chairman, so I will stop right there.
Thank you.
One bill at a time, but you do have some good folks here supporting the bill. It's a couple friend and constituent, Dr. Gene Bailey's back there, so you're in good company. But Senator Muse, go ahead.
Chairman, and thank you for this bill. I think it's a good bill, and I think the discussion and as always tweaking of any bills can also make it a better bill. Probably for me, the broader issue is, for me, as I look at this bill, whether it is for that particular family or for African Americans as a people, it's also about the preservation of history. And I think that's important in a day when There are those who want to cancel our history and don't want to look at the history to do all that we can to preserve it. As I look at the bill, I want to ask again, can you define, I don't see where it's defined in the bill, and if you can get back to me. Just looking at what my colleague said, what is a person or who is a person of interest? Does that need to be tweaked at all in the language of the law to make it specific so that one doesn't see it as a all come, anybody can come, all can come, etc. Then if this becomes law, what's the penalty? What's the recourse? What happens if one says, in spite of the law, you can't come and visit this grave, or we're going to build on it anyway? I mean, I know in other parts of the law there are some provisions that may address this. And I ask that because a number of my churches have cemeteries, and then some of them decide they build a larger church and they move, and the land is taken over by developers. And generally, there's a agreement between us as a denomination and the buyer to allow persons to visit, et cetera, et cetera. When that's not the case, what's the recourse? And the defining maybe the person, what is a person of interest? I think that will help others to look at it a little more.
Yeah, thank you, Senator. So the person of interest is defined in this legislation. And I think Senator James found it. I'm flipping to it, trying to listen to you. So
It's in the statute.
it's in the statute, yeah.
Relative to this bill?
Yeah.
Yes. Okay, thank you. Okay.
Yeah, so
and
so if you like I said, this bill is in your hands as a committee, so I invite you to make it better. And so I would appreciate that. Thank you. And so the second part of your question, it kind of slipped my brain. Do you want a response from me, this other part, or
if you want to?
What's the second? Can you summarize that really quick?
What's the recourse if someone?
Oh yeah, the recourse. Thank you for that. The recourse is, of course, like my other bill, which was presented last year, there are no penalties of misdemeanor or anything like that. But if you think if someone violates the law, they can be sued, right? You can take them to court and say, hey, the law allows me visitation, you're not allowing me visitation. And you can present your case in front of a court. And the court says, yes, Mr. Property Owner, Ms. Property Owner, you're not obeying the law. The court can have sanctions, right? The court just can say, hey, obey the law. And the person says, I will not obey the law. The judge can sanction that person with contempt or whatever. So there are avenues, but we don't want any criminal penalties. We don't want any misdemeanor felony.
Right.
This doesn't rise to that level, in my humble opinion.
Thank you. Thank you, Mr.
Thank you, Mr. Chair. Sorry to have a second bite at the apple, but as you could, I'm sure appreciate from my earlier questions, I'm troubled by this bill. In between my earlier questioning and now, I went online. I would call your attention and ask you to go back and read the Supreme Court decision in Nick, K-N-I-C-K versus Township of Scott. They decided it on June 21st, 2019. In that case, Mrs. Nick owned 90 acres, probably still owns 90 acres of land in central Pennsylvania. She had a house on part of the land and used the rest of the land to graze cattle and horses. There apparently were some grave sites on that property. The township passed an ordinance requiring her to open up her property to strangers at various times so they could come onto her property and visit. She alleged that this was a taking under the takings clause of the Fifth Amendment of the U.S. Constitution. The Supreme Court agreed with her and issued a decision saying that this indeed was a taking under the Fifth Amendment, an unconstitutional taking of her land, because no compensation was being granted for her the requirement that she open up her property to people who she didn't want to have on her property. So my suggestion to you is go back and read that decision and then maybe revisit this bill to see whether or not you want to revise the bill in some way in order to avoid the constitutional problem. Thank you.
Yes, and could I say that the bill drafters and we went over these concerns, and we narrowly tailored the bill to a few days per month. So, and it's open up to persons of interest, not just the general public, that anyone can choose. And so we narrowly craft the bill to hopefully pass constitutional muster, Senator. So
It's only a takings unless there's absent just compensation. And so maybe you take that $2.5 million and, there you go. All right. Bad joke. All right. All right. Seeing no further questions, thank you very much, Senator. And Ms. Gilbert, thank you very much. This is really enlightening. Your testimony was great. So thank you for taking the time. It was great.
Okay.
Really.
Thank you, Senator.
All right. So with that, that'll conclude the hearing for Senate Bill 105. We'll now move on to Senator Washington. Senate Bill 141. Welcome back to JPR. We miss you.
I know.
I know you miss us.
I do.
Welcome back. Senator
thank
Charles is looking over there like,
All right. Thank you, Mr. Chairman and members of the committee. Senator Alonzo Washington here for the record to present on Senate Bill 141, a bill in which you've heard multiple years in a row. But I was told on the Senate floor twice this week that if I keep my testimony short, you all are going to move this bill. So I promise to do that today. So this bill just requires that condo associations across Maryland develop a policy to ban smoking within dwellings that have multiple units or condo units that are connected, essentially. As I said before, this bill came up because many residents have come to me that live in condos that say that there's a nuisance or a issue with smoking that enters into their home from their neighboring home, where they smell smoke and there's no recourse for them. Even in the testimony from you'll hear from the Attorney General's office, they have no recourse and they hear these complaints all the time from neighbor to neighbor disputes, and it's hard for them to try to find a resolution for this. And so this bill would just require that there be that the condo association, they can make whatever policy they want. Again, we don't tell them, they can say smoking is allowed here. They can say smoking isn't allowed. That's totally up to the condo association. This is totally up to them. We're just saying create a smoking policy, just as if you will create a noise ordinance or a noise policy. And so only thing that what is required in this and for consideration for the condo association within that policy is that they choose a location where smoking is allowed on the premises in common area locations. Any conditions on the ability to smoke in areas where smoking is authorized, potential fines for violations of the policy, and guidelines to submit a complaint about the policy violators. Again, we heard last year from the opposition that this was a requirement, that they have to say no, that you cannot have yet you cannot have a common area where you smoke. Or we heard from the opposition that they have to impose a fine. They do not have to impose a fine. The fine could be $0. They don't have to do that at all. This bill is just saying that they shall consider these things and put them into their policy. This has been done previously in other states like Colorado, Delaware, Hawaii, Maine, New Jersey, New York, North Dakota, and Rhode Island. I'm asking for a favorable report on this bill because I think it'll be important for the sake of our families we now have legalized marijuana, and there's been smoking for decades and years. And we want to make sure that there's a recourse that someone can take that have lived in their apartment, that lived in their condo for such a long period of time, where smoking is seeping under the doors into their home by that neighbor. And so there's a ordinance that's there that can hold that neighbor accountable, because people deserve to breathe clean air. And so for those reasons, Mr. Chairman, I ask for a favorable report on SB 141, excuse me.
Excellent. Thank you very much. I know you have a panelist. I'd like to bring your panel up first, and then we'll take questions. Senator Folden's first and the questions, but if your panel would like to come on up, provide testimony, then we'll move forward. Ms. Harris, welcome. If you could come up to the podium, that'd be perfect. Thanks. Thank you.
Thank you. My name is Karen Strawn, and I'm with the Maryland Office of the Attorney General. And I appreciate the opportunity to testify on this bill. In the Consumer Protection Division of the Office of the Attorney General, we regularly get calls from people who are concerned about their neighbor and the smoking that's occurring. Whether it be that they're in an apartment complex where sometimes we can do some things, but if it's in a condominium association, these are unit owners and you can't easily move a unit owner. They would have to move out. But if a smoking policy is developed, that would tell them before they purchase whether or not this is a place where they can expect that their neighbor might be smoking that might come into their apartment, excuse me, their unit, or whether there might be smoking in certain common areas of the facility. And for those reasons, we think it's important that this bill be passed because it allows opportunities to work in situations to make sure that people are purchasing their homes in the environment that they are hoping to purchase in. They're purchasing their homes in an environment that can remain clean, whether it's because they're on oxygen, they have asthma, they have other medical conditions that require a clean environment, or just because they don't like smoke. And this becomes even more of a problem now that we've passed marijuana, because there are going to be even more people who are doing smoking and things like that that might pass into a unit where someone with a medical condition may not want that. So we appreciate the opportunity to testify on this bill and we urge a favorable report.
Excellent. Thank you very much. All right, is anyone else on the panel? I have a couple of their names here, but no hands here. Okay, excellent. We'll open to questions. Senator Fulton.
Thank you, Mr. Chairman. So whoever wants to answer it can, but so I believe this is one of the issues that many of my colleagues and I tried to argue about before we legalized. And when I say we, I don't mean me, because I was opposed. Marijuana usage. And I believe we spoke about, having youth exposed to it, having, unfettered access to this now, these gummies and brownies and everything else. Now, those don't make smell, right? But the smoking amount, I mean, how much smoke are we talking about that's causing problems here? Is it the smell or is it the smoke? Because I will tell you, the smell it's unmistakable. And it is, for me, horrible. Which I'm going to guess is some of these homeowners are saying the same thing. They don't want to smell weed, the odor coming through, because it's very strong, especially if it's good bud.
We could come up to the podium and provide good testimony and commentary on that good bud. That'd be great. Thanks.
It's fair.
The complaints that we've received and the phone calls that we've received have been generally about probably there's an added aspect of it that is the smell. But when they call us, they're telling us, look, I have a medical problem. I really need to have a clean environment.
Yeah.
And, I presume that they're being truthful. We are in a difficult position with a condominium that there's really nothing we can do. In an apartment complex, we can work to try and move the person. We can work to try and get an agreement between the parties about when they would smoke and not smoke, things of that nature. But you can't really do that when it's someone's residence. And they're telling us that it's medical problems.
So I'm not going to question anybody's integrity. Having said that, unless it looks like a scene out of Cheech and Chong where the smoke is billowing out, I don't understand how that is so, other than the smell. I believe the smell is a problem. And I know that a lot of people do not like the smell because it gets embedded. I mean, you go up to somebody anybody's walking down the street, you can tell who's smoking marijuana. It just stays there. So I understand that. Look, again, I don't have a problem with the bill per se. I don't. I just think that we're now getting into the weeds of something that we tried to alert people to that nobody wanted to hear. They just wanted to run, down the hallway, scissors point up, to legalize weed. And now everybody's got what they got. And now some people aren't happy about it.
I would just say that, first, thank you for the questions or comments. I did propose this bill before we actually passed a law to legalize. I've introduced it before in the past, trying to get it done because there are folks that just smoke regular cigarettes where there are pillows of smoke that come out the house or that goes door to door. I grew up with a smoker that when you walk through the home, there was smoke everywhere. So it does happen. That is a big issue, and we've seen it. It is happening, and there's no recourse for it. What this bill says is that for these folks to create a policy, whatever the policy is, the condo association agrees to it, and they move forward. We just want to make sure that there's protections for those folks that are actually, having smoke coming to their home so they can have a recourse.
But aren't we in this bill, isn't it taking away someone's individual right then?
No.
To exercise if they want to smoke weed?
No.
In the comfort of their home on a parcel?
If it doesn't bother the neighbor, then no. But again, this bill does not take away anyone's rights for any reason. This bill says that to create a policy.
Yeah, but
we don't outline what the policy is.
Creating a policy for some property that someone owns legally, they pay for, they have a mortgage for.
Correct.
To prohibit certain activities within the walls of their home.
I think what you're failing to realize, there's nothing here that says prohibit smoke. There's nothing in this bill that says prohibit smoking.
What would the policy be then? If they
the
violate
policy, the policy will be totally up to whatever that condo association says they want. They can all say they want smoking, and it'll be completely fine. And that's it. That's it. They can do nothing. It's totally up to that condo association. We're just saying, so create the policy.
So this is puzzling my puzzler.
I don't know why.
We passed legislation 2 years ago or 3 years ago about moving the smoking age up to 21, but there's no penalties now associated, civil or otherwise, for a 13-year-old that smokes. So we're talking about, I just don't understand this. We keep moving measures forward and we make it the problem worse, because now it doesn't matter if you're 13 and smoking. There's no it's a policy, but there's no bite to it.
Yeah, no, that's
but you got to be 21 to smoke legally in the state of Maryland.
I think that's a different bill.
It is, but it's similar in nature in that we're moving stuff forward so fast that we're like, yeah, let's get it through. And then we don't think about the collateral damage that happens, the unintended consequences. And this is one of them. And, I think it's a property owner's, I think it's a slippery slope when you're telling people what they can do in their own confines of their own legally owned property.
To be clear, we're only asking for a policy. The condo association determines whatever that policy is. We're telling them to create one, and that's it. There's nothing in this bill that prohibits someone from smoking in their unit, outside of their unit, on their grass in the field of their property. We're just saying create.
So we're creating a policy with no teeth that says
it does give the condo association the ability to create fines if they choose to do so, to consider creating fines.
It's just like any other condo, like how tall your fence can be, what color any condo association makes rules, like pet policies, all that stuff is subject to whatever the condo association.
Thank you.
Makes up.
Thank you,
Senator West.
Thank you, Mr. Chair. It's great to see you back again. Wouldn't you like to return permanently to our committee?
My seat, I still got some stuff in the drawers there.
So I just have a couple.
That's funny, but it's not funny. It's like a carousel over here, man.
I just have a couple of questions. Why does this only cover condominiums and co-ops? Why not apartment houses?
Most apartments already have a policy instated, and so in working with some of the advocates, we decided to just focus on condo associations and not apartments.
Okay, and then my other question: there's a opposition filed by the Maryland Legislative Action Committee of the Community Associations Institute. Have you seen that?
Maryland.
Let me read you the relevant part. It says, it's exceptionally difficult for a community association to penalize violators of a no smoking policy because there's often insufficient proof of the source of the smoke. Smoking complaints are often unsubstantiated complaints from a resident who believes smoke is emanating from a nearby unit or common area, but has no definitive proof of such a claim. Then it goes on and says, by mandating a multifamily dwelling to adopt such a policy, The bill is inadvertently requiring a multifamily dwelling to enforce such a policy that it's difficult, if not impossible, to do. This could lead to claims against the multifamily dwelling for failing to enforce such a policy. So their concern is the bill is inadvertently going to cause these the condominium association or the co-op housing corporation to be sued by disgruntled residents that they're not enforcing some policy that this bill requires them to adopt. How do you respond to that?
There's a policy in condo associations that says you can't have your trash outside for more than 24 hours. And that leads to contention just as well. And it's hard to, determine if it's been out there for 24 hours or if it's been out there for 30 hours or 15 hours or whatever have you. So it's just, to me, there are ways, and I'm gonna have my colleagues here just answer that directly. But I will say, over the last 3 years that I proposed this bill, every year increasingly we've gotten more people to want to testify or submit testimony in favor of this bill, to move this bill forward, including the council members from Montgomery County, including the Office of Attorney General and others, and you guys have the list there. But I just want to point out that there's only about 2 people who signed up to in opposition to this bill, but there's multiple folks, and again, in increasing fashion every year for folks who want to support this piece of legislation. I'll let my colleague answer that question directly.
Thank you. When there's a policy that's made up, generally that's going to fall under the rules and regulations, which means they're going to make a determination of what they think the rule should be, send it out to the community is going to vote. So it's going to be the majority of the community that is going to be in favor of whatever policy is chosen by the association. You may have a minority that has problems with it, but you may have a minority that has problems with everything that an association does. So I think that this is something that most people will buy into because they would get the right to vote on what that policy is.
Well, what about the concern that if the association doesn't enforce the policy, that it would be subjecting itself to possible lawsuit by people living in that facility that are upset that the policy is not being enforced?
Well, I unfortunately think we live in a litigious society that a lawsuit is always possible whenever you pass a law. But I think that in most cases, individuals who are not happy with the fines not being employed are going to file a complaint with our office. And we're going to work with the association and try and see what we can do to help keep both sides happy.
Okay, great. Thank you.
I don't want to push this on any longer either, but so someone's going to file a complaint with your office, or the condo association would file a complaint with your office, then you would be responsible for to talk about that process. In terms of meeting the burden,
When someone files a complaint with our office, we mediate those complaints. And by mediating, it's voluntary on both sides, but we work together with the parties and try and get them to come to an amicable resolution. So it's not something that's mandatory on either side. It's not something that we get in touch with them and say, you have to put that fine in force or anything of that nature. It's something that we would be talking to them, trying to work out a resolution that would be something that would make all the parties happy.
In terms of the investigatory piece, or that's still, where does that that's on the condo association is?
That is on the condo association for the most part. If we found that there was a particular condo association who was having a number of problems in this area, there's always the opportunity that our office could take an enforcement action, but I find that very unlikely that that's something that we would get enough complaints about that we would take against a particular condo association or co-op.
Got it. So, all right, see no further questions. Thank you very much. That concludes testimony for the proponents of the bill. We'll now switch to the opposition with Mr. Boriano.
Good afternoon, Mr. Chairman and members of the committee. For the record, Bruce Boriano. I'm here on behalf of the tobacco wholesalers in very strong opposition to this legislation. I've testified before this committee 2 years in a row against this bill, and it's back again. It's important to understand the bill covers smoking of cigarettes, cannabis, and cigars, a lawful activity in the state of Maryland among adults. The bill also applies to existing longstanding condominiums and apartments, not new construction, not new people. So it would impact, if you pass this, to people that bought their condominium, they're happy, they're satisfied, and all of a sudden they're being told what they can and cannot do in their unit. Please, I urge you, please read this bill. Let me just take a moment, okay? If you go on page 2 of the bill, down to line 26, please. The policy under subsection C shall state, it's mandatory, that the condominium association has to state the locations where you can smoke on the authorized property and where you cannot smoke. Shall is mandatory, not permissive, not possibly. And then you come on over and they shall develop penalties. Penalties are undefined, could be incarceration, could be a monetary fine, what have you. And the thing that's not discussed in this bill, and I will come to a conclusion, is on page 3 of the bill. Please look at lines 10 through 13. Excuse me, not 10 through 13, 6 through 13, where the bill says that notwithstanding anything else in this bill, it gives the counties and municipal government the authority to enact more stringent laws than what this bill is. So what you're talking about is trying to reach a balance. Does not have to be done at the local level by passing this. It's very clear that was not addressed. This bill was not favorably considered in the past. I think it's overreach. I think the things that Senator West raised are very valid in terms of suing the condo association and what have you. And you just passed cannabis, and it's an issue. But I would urge an unfavorable report. This is the intrusion on using of products that are lawfully done by adults. I'd be happy to answer any questions you may have.
Seeing no questions from the committee, thank you.
Thank you, Mr. Chairman, members of the committee.
All right. And with that, that'll conclude the testimony for Senate Bill 141. I see Senator Guile is here. We'll now move on to Senate Bill 159. Senator Guile, welcome. Do you want to bring up your panel?
Yep, on the way up. Thank you, Mr. Chair. Members of the committee, you have my written testimony, so I'm going to try to be as brief as I can in the interest of time and the realization of the amount of work that you will be working on this session. SB 159 is a bill that was presented to me by military historians. Just to give you a little bit of background about what happens with military personnel records. After discharge, they're held by the National Personnel Records Center in St. Louis, Missouri. After a certain period of time, after 62 years following discharge, they're at the National Archives, and anybody can get access to those records. The problem is in 1973, there was a disastrous fire in Missouri and destroyed a lot of military service records. However, some clerks of courts do indeed have military service records. And the reason is years ago, people would take some of their, important records, whether it be wills or things like that, including military service records, and give them to the clerk's office for safekeeping. And so the clerk's office do indeed have a lot of military service records. The problem is what we have right now is the existing law does not allow anyone to have access to those records unless you're a family member. And so what this bill would do is essentially sort of align it to what the access is right now for the military service records at the National Archives, and would say that those discharge papers that were submitted to clerks at least 70 years ago are considered a public record and does not need a family member or somebody to sign off for release of those records. And then it would also redact those social security numbers on the newly released discharge papers Social security numbers haven't been around for that long, but looking forward to the future, making sure that those identifying information will be protected going forward. I do have a member from the Anne Arundel County, or our clerk of circuit court from Anne Arundel County here with us, as well as other advocates to testify a little bit further. There is, I would note, a friendly amendment that was submitted to the committee in my written testimony that would just state that the county clerks clarified that only the newly released records must have social security numbers redacted, just not placing the responsibility on clerk's office right now to go through and redact all those records. So they only be redacted upon release. And so with that, I would ask the committee for a favorable report. Thank you, Mr. Chair.
Thank you very much. We'll hear from the panel next.
You can actually speak right there if you want.
No, actually, can we
do you want to be
podium? Yeah, sorry, yeah.
Okay, sorry.
Thank you, Senator Guile. Thank you, Chairman Smith, and members of the committee. For the record, my name is Scott Poyer. I am the clerk of the circuit court for Anne Arundel County, and I also represent the 24 elected clerks of the circuit court for the state of Maryland, who are the keepers of the record for the military discharge papers that this bill refers to. The clerks of the court have reviewed the bill and requested the sponsors' amendments. Sponsors indicated they are making, and regarding when the records should need to be redacted, which would be when they're eligible for release after 70 years. With that amendment, the clerks of the circuit court request a favorable report from the committee on this bill. And we would like to thank Senator Guile, Senator Beidel, Carozza, Klausmeyer, and Smith for sponsoring this bill. I am available for questions. Thank you very much, Mr. Chairman.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, and esteemed members of this committee. My name is Lisa Rodbian, and I represent District 6 on the Anne Arundel County Council, which is right here in Annapolis. But I'm here today speaking in my personal capacity. That said, my work on the council is what brought my attention to this issue. If you are like me, many of you would be surprised to learn that there are many Maryland-born veterans of foreign wars who are buried in unmarked graves in cemeteries right here in our state. This includes both those who lived after their service ended and those who were killed in action. I did not know this until recently, and I'm sort of appalled as a nation that we've let this happen. This includes both men and women. It includes, for example, veterans who stormed Omaha Beach on June 6, 1944. It includes veterans who fought or were killed in every foreign war in our history. It is also very likely that soldiers of color are disproportionately without proper headstones, particularly as you go back further into history. The good news is that there are nonprofit organizations who are working to correct these shortcomings. They need your help, however. In order for these organizations to help advocate for the proper headstones and really to collect the full history for these soldiers, these advocates need access to certain documentation. In particular, they need the soldiers' discharge papers, which is also known as the DD-214. As you heard, copies of these are housed in the clerks of court in each of our courts in each county across the state. Obviously, there are privacy concerns that should limit access to personnel documents. This bill has been carefully vetted and crafted to create a narrow path, however, for releasing these documents. They are only available where an individual can show good cause and at least 70 years have passed since the document was issued. Furthermore, social security numbers are redacted, as you heard. And so my simple request is help our historians honor our veterans, both who died after their service and were killed in action, by allowing these nonprofits to go forward and help honor their memory with proper headstones and history. Thank you.
Thank you, Chairman and Vice Chairman and members of this committee for the opportunity to testify in support of Senate Bill 159. For the record, my name is Denise Robinson, and in 2016, I founded the Legacy of Honor Project, researching, telling the stories, and honoring the men and women who served in World War I and World War II, with an emphasis on the men and women who died while serving. I could list dozens of reasons why access should be granted. The massive fire at St. Louis Archives, 12 July 1973, that destroyed 80% of our World War I and World War II personnel records, making the only complete and accurate record of a person's service their discharge papers. But for me, the number one reason, the discharge papers are proof that a veteran is entitled to a headstone provided by the VA. When I first started the Legacy of Honor project, what surprised me, the number of men who had served or who had died while serving that are lying in unmarked graves. I discovered the most common factors of these men. The family was poor, persons of color, an only child, they never married, or one or more of their parents died before or shortly after they were buried. All were buried before 1955. All the documentation needed to request a headstone, service number, unit, enlistment date, discharge separation date, most importantly, the stamp at the top that says honorable discharge are on this one document. 170, 50 years after they've been laid to rest, many times researchers like myself are their only voice. Yet because the way the law is written now, we can't access the document, making it more cumbersome and at times impossible to place a headstone on an unmarked grave. It does not matter if I can prove a service member was awarded a Purple Heart for wounds received on Omaha Beach, 6 June 1944, or a Bronze Star with Valor for crossing the Roaring River on 23 February 1945. The only thing that entitles this person to a headstone is proof of their honorable discharge status. I urge the committee to give a favorable report on SB 159 so we can accurately tell the stories and honor the men and women who protected our freedom. Thank you very much, and I'm here if you have any questions.
Thank you all very much. Senator Charles.
Thank you, Mr. Chair. I have two questions. One, that fire had a lot of impact on veterans getting access to their records when they're trying to do their VA benefit applications. As I was reading through the bill, it says book or electronic record. Is there a reason why we're not focusing specifically on just having an electronic record to make sure if a fire ever came back again that hit us and we lost some of these books of record, these vets still had access to, or you guys had access to the records at least?
Thank you, Senator. I'm going to let the clerk answer that question since he's much more familiar than I am about the recording of and keeping of those documents. Go ahead.
The fire was at the federal facility that keeps those records, the National Personnel Records Center in St. Louis. They're adopting electronic records now. At the time of the fire, they were all paper. Our records here in Maryland, they're paper right now. The law requires it to be paper. Part of this bill is that we be allowed to adopt new technology, update those records to make them digital so that this doesn't happen again. This bill would allow us to keep them in paper, and those could be transferred to the archives or adopt them as digital, and then they'll be protected.
Yeah. Whatever law that is mandating things be kept in paper is not keeping up with the times. So
this bill changes it, and we thank Senator Guile for sponsoring that.
Yep. And so my last question, I was listening to like what the actual records are, and if it's a DD 214, is it access to your medical records? Is it access to, disciplinary actions that a soldier had gone through, or is it just, what is it specifically when we're talking about records and getting access to?
Straight DD 214.
Okay.
It's my understanding as well that I think you need a HIPAA authorization typically in order to get any medical records that are included in a military service record. But to the point, though, I believe that any of the records that the clerk's office has is limited to the DD 214s.
Is there a reason? Is there something that needs to take place in order for you to have access to the medical records? And I only ask this because I got a lot of different constituents. Prince George's County has the highest amount of veterans in the entire state of Maryland. And we have a lot of folks when they're trying to get access to their medical records so they can do their VA compensation package to see if they can get any benefits from them, and they don't have access to those records at all. Is there any rational reason why you guys shouldn't have access to the medical records to make it accessible?
If I may answer, so the records that are kept at the clerk's office, and I think the clerk here can also clarify to the extent I'm inaccurate. These records are aged from years and years ago. With respect to any of the medical records for service members now, or any service members that are, recently separated from service, I can't necessarily speak to that. I mean, it's my understanding that for the most part, the records that are kept at the clerk's office are from years ago.
And the senator is correct. And the law was originally set up in 1941. So our records date from June 1941, because that's when the original law was passed in Maryland. and it was only for discharge records. So the only thing we keep are discharge records. The law would have to be changed if the legislature wanted us to keep other records, but now those records are available from the National Personnel Records Center, and they would be available from them. But our historic records go from June 1941 to date. The vast majority of the records are from before the computer age, because back then, if you didn't keep a copy of your paper record somewhere like the clerk's office, it might be destroyed and then it was gone. So it was much more common for people to file paper records with us, file them with the clerk's office back then. Now that the computer age is, now that we're in the computer age, we get fewer of those records. We still have some, but the value to these are the historic records that after the fire don't exist anywhere else.
So if I go to my clerk, Prince George's County Clerk of the Court's office, I can get a copy of my DD 214 from there?
You have
No.
to submit, oh, I'm sorry. You have to submit it to us.
Okay,
That's another thing. Nobody has a complete record. That's a very good question because nobody has a complete record anymore. The only records that the clerks have are what's been submitted to us by the filer, by the person who has the DD 214. If they didn't file it with us, we don't have it, but nobody else does either. They're the most intact records that exist right now.
thank you for the answers and thank you, Mr. Chair.
Yeah, I was wondering about that. Who had access to like my fit reps or like, all that good stuff. I'm like,
We'll
oh,
look, we'll look you up.
we're all good. Though.
Chair.
I got promoted. Okay. So it's all, Okay. All right. No further questions. Thank you very much for this bill. It's great.
Thank you.
Thank you. And that will conclude the hearing for Senate Bill 159. We'll now move on to Senator Augustine, Senate Bill 171. Senator Augustine, welcome back.
Thank you. Thank you, Chair Smith, Vice Chair Wellstreicher, members of the committee. Senator Malcolm Augustine here on behalf of Senate Bill 171, Landlord and Tenant Office of Home Energy Programs Financial Assistance. Colleagues, the reason for this bill is that we have Marylanders who are eligible for energy assistance, and we want to make sure they can get it. Like, that's really what this is about. And we have Marylanders who are renting and they may have a landlord in the land, but they qualify for these benefits. But the landlord may or may not be willing to help the renters to be able to access those benefits. The bill as originally drafted was a little bit complicated, okay? And I would ask that you guys see at the back of my written testimony an amendment that really, really simplifies what we are planning to do with this bill. And this amendment was done in consultation with the Department of Human Services. We talked about it. We tried to get this to be something that would be a little easier for them to administer. And so what the amendment does is it says that we already have in Maryland real property law that if a landlord has the tenants pay for like the water bill, that they have to share the actual bill with the tenant. And so that the tenant would have the information for the water bill. Now, what this amendment does is just says that let's add on to that they have to share a gas or electric bill. So what that does is that then gives the tenant the information that they need, which is actually the bill. They need the bill in order to apply for the benefits from the Office of Home Energy. So that's how with this amendment, it really, really simplifies what we're doing. The landlords are already required today to share a water bill. Now they would just be simply asked to share the additional information of an electric or gas bill. Really removes the real barrier to Marylanders who are already qualified for this home energy assistance to be able to access it. So what I would ask is for the support of the committee on the amended bill, which has been submitted to the committee. Thank you for the opportunity to share, Mr. Chair.
Thank you very much. We'll hear from your panel and then take
Great.
questions from the committee.
Please.
Good afternoon, Chairman, Vice Chairman, who I think wandered off, and esteemed panel. I'm James Wolf, Maryland Legal Aid, speaking in favor of this bill. Senate Bill 171, as amended now, simply expands what bills need to be provided to tenants to get assistance. In this scenario, this happens for legal aid constantly. We have RUB systems in place that create convoluted aspects for our clients. Landlords choose to either pass along these expenses or not pass along these expenses. And when it's not passed along, it's oftentimes included as additional rent, where our clients are getting charged for this, qualify for assistance, and simply just don't have access to it because there's no other obligation for the landlords to provide that information to their tenants. By requiring that information to their tenants, it is produced to the tenants so they can get those assistance. Those assistances are always tied or generally tied to production of the bill to ensure that those benefits are then released to the correct account and to the correct person that qualifies for those assistance. Without those records, there's simply no way to be able to track them. I do see this regularly in my work as a housing attorney, where people qualify for these benefits, they've applied for these benefits, and landlords are under no obligation to provide the documentation for them to get these benefits. Aside from a landlord just opting not to provide them, there's no legal avenue to force them to provide them. And our clients are oftentimes not being able to get benefits that would keep them from homelessness, from keeping them from having their lights turned off. Because an electric bill, while it's not an eviction, an electric bill being shut off does oftentimes lead to a breach of lease because temperatures in the winter in most tenancies need to be kept above a level to keep the pipes from freezing. And we need to avoid those issues by allowing them to get proper access. And as such, we request that this committee give a favorable report for this bill. Thank you.
Thank you.
Chairman Smith, Vice Chair Wall-Striker, and members of the committee, thank you for the opportunity to testify in support of SB 171. My name is Ali Sarine, and I'm a member of the policy team at the CASH Campaign of Maryland. CASH stands for Creating Assets, Savings, and Hope, and we promote economic advancement for low to moderate income individuals and families in Baltimore and across Maryland. More than half of our clients earn less than $20,000 per year, with many earning less than $10,000. CASH provides a variety of services to Marylanders, including free tax preparation and benefits screening. Last year, our benefits team worked with over 600 households across the state to receive benefits, including OHEP's energy and financial assistance. OHEP provides financial support for low-income households through many ways, including with their energy and utility bills. According to Prosperity Now's most recent scorecard for Maryland, 20.2% of Maryland households experience income volatility, and 26.7% had difficulty paying for usual household expenses. This shows that at least 1/5 of Marylanders struggle to pay for basic expenses, including rent. Individuals and families are struggling to pay to live in Maryland, and SB 171 would provide low-income households with some financial relief that they're qualified for. Requiring landlords to accept payments from OHEP would serve CASH clients and low-income Marylanders across the state by providing both financial support and housing assurance. For these reasons, we urge a favorable report on SB 171. Thank you for your time.
Good afternoon, Chairman, members of the committee. My name is Albert Turner. I'm the staff attorney with the Public Justice Center, as well as representative for the Renters United Maryland. We are offering this testimony in support of Senate Bill 171 and along with the amendments that have been offered by the sponsor of the bill. Just a little bit of background. I spoke with the delegate Charkoudian about this bill, who is the sponsor in the House. And something that she spoke, and I'm sure she's doing it right now in the House, is that OHEP has the money to provide tenants with energy assistance. The issue is that one, a lot of tenants that we represent in Baltimore City do not know about this program, don't know how to access it. And sometimes the landlords, they don't do their necessary due diligence and and allowing tenants to apply for this assistance, which would help the landlord as well as help the tenant. Now, with that money being there, this would kind of work like rental assistance, right? The rental assistance that worked so well during the time of the pandemic, where the tenant would be able to have access to the funds that are already allocated through OHAP to apply and get the rental assistance or the utility assistance that is needed for this for whatever usage that they have. With that, we would request a favorable report with the amendments as sponsored by the sponsor of this bill. Thank you very much.
All right, thank you all very much. Questions from the committee? All right, seeing none, thank you very much, Senator Augustine, and thank you to the panel. That will conclude the hearing for Senate Bill 171. We'll now move on to Senator Lewis and Senator Bold. Hey, how are you? Come on up. Senate Bill 125, Senator Lewis. And Senator Bolden, the senators from Frederick.
Good afternoon, Chair, Vice Chair, members of the committee, Senator Karen Lewis Young for the record. This bill will sound familiar to you. You passed it unanimously as a local bill last year. It's coming back in a different posture, and I'm going to briefly refresh your memory for the bill and tell you why it's coming back as a statewide bill. First, I want to review what Superfund means. A Superfund is an informal name for the Comprehensive Environmental Response, Compensation, and Liability Act. This was established by Congress to handle emergency hazardous waste sites needing long-term cleanup. You might remember that Love Canal was the first Superfund site. We have 26 Superfund sites in this state. In fact, 4 members of your committee represent counties that have Superfund sites in it. And that leads into why it's a state bill. So when this bill crossed over to the House, they loved it. They thought it was a great bill, and they said it should apply to the entire state. Unfortunately, we didn't have the time to make that change, cross back over, and so here we are. I'm going to give you a brief overview of what the bill does, and then I have a few panelists, I believe 2 should be on remotely, that are going to drill down on some of the specifics. So what this bill would do is it says, there will be an addendum to the sales contract that would identify which Superfund site is within half a mile of the property being sold. It defines what a Superfund site is. It says, it will say where to find Superfund guidelines, resources, information. And also it would contain a notice to the property buyer, letting them know they have 5 days after receiving this addendum to rescind the contract. I want to give you just a little bit more information about why this bill is important. Research shows there are significant health effects that most likely occur actually within 1.8 miles of a Superfund site. So this 5-point mile is, we believe, a modest compromise. We have been working for the past 9 months with some entities that opposed the bill last year to come back and seek a compromise. They are coming back favorable with amendments, but some of the same items that they opposed last year. I'm going to summarize where we have disagreements, and one of my panel members will drill down on that. But before I mention that, this is also very much a health equity issue, as well as a health safety issue. Black Americans are 75% more likely than the population overall to live within close proximity of a Superfund site. So here is our disagreement with some of the favorable with amendments. One is the issue of transparency. We don't think this should be treated like a simple buyer's notice. This is pretty significant stuff and it needs to have transparency. The other issue where we're currently in disagreement is the site that an individual purchasing a home within half a mile should be referred to. We are recommending a site that's been endorsed by the EPA. And those that don't agree with the site we've recommended are recommending a site that is in a testing phase. So the second area of disagreement is accuracy of information. So with that overview, I'd like to turn it over to my panel to do some specific drill down.
Good afternoon. Okay. The Realtor's proposed amendments have nothing to do with the current draft's intent. Information about an MPL Superfund site poses too high a danger of contamination to the buyer to be slipped in as a non-conspicuous buyer's choice. Only sites that score high enough in the hazard ranking system are placed on the national priorities list. The Realtors suggest a website called the Superfund Enterprise Management System, and that is misleading. The site is misleading. It is not specific to MPL Superfund sites and not user-friendly per EPA headquarters or EPA region representatives. Only 10% or less of what is on that list will end up declared a Superfund site on the national priorities list. The URLs in our bill are the correct tools to find MPL Superfund sites, and you can test them yourself for your district. The Realtors remove the right to rescind in Section D of their suggestions, leaving no recourse to the buyer. The 5 days notice based on the information provided must stand. The Realtors argue that even mapping technology on a website is not guaranteed to be exact. That is even more of a reason why the half mile is appropriate. As data is gathered, the perimeter of known contamination expands. This will change the map over time. The disclosure of proximity is at the time of sale and allows for 1/2 mile for this very reason. The Realtors' amendments do not address any and all residential real estate transactions, leaving exemptions to this disclosure. The Realtors assert that a buyer should be in control. We disagree. Because of the magnitude of the potential hazard, the expert, the Realtor who should know his location, should have the responsibility to provide NPL Superfund site information. We insist that the bill stand as written. Thank you, gentlemen and ladies.
Hi, what is a Superfund site? The Environmental Protection Agency defines it as a hazardous waste site that poses a risk to human health and the environment. A smaller segment of the Superfund sites are the national priorities list. These sites are selected because they warrant further investigation into the risks such sites pose and whether cleanup of the site is warranted under the Superfund remedial program. The sites on the MPL are the worst of the contaminated sites. This investigation is to try to characterize the extent of contamination. The process is slow and thorough. It could take 10+ years. In Maryland, we have NPL sites that have been on the MPL for over 20 years. Here are a few examples of sites. Fort T Creek was used for dumping and crop testing. From 2001 to 2004, there was an interim removal action of 4 disposal pits in Area B11. After excavation of the first pit, the process changed. Why? The discovery that explosive, reactive, and biological contaminants were present in Area B11 pits. This necessitated changes in the excavation system in order to protect human health and the environment from potential air releases. When the word explosive is used, it means explosions and fires. Please note that experts believe this activity was not caused by munitions. Another site's Indian Head Surface Warfare Center. It manufactured munitions and chemicals. Site operations also created explosive, reactive, and hazardous waste. And these products were dumped into septic systems, pits, sewers, and they emptied into the surrounding water. There are 114 areas to be studied on this site, and only 12 of them are being looked at right now. Thank you.
Thank you, Senator. To the panelists, questions from the committee. We have Senator West.
Thank you, Mr. Chair. So can I talk to the sponsor of the bill for a
Sure.
moment? So everything, and you better go up to the podium because otherwise you won't be on camera. Everything in the bill is hinged on this 1/2 mile from the Superfund site. So Fort Detrick is a large tract of land. Presumably the entire land is not a Superfund. There must be places on the land that are Superfund.
Well, we're most concerned in Frederick about Area B. And that's where over a period of decades, hazardous waste was dumped. This 1/2 mile really was a compromise. As I mentioned, there's scientific evidence that these vapors and waste can travel up to 1.8 miles. There's also some national guidance that states 0.62 miles, but as I mentioned, 0.5 is a compromise.
Okay, and it's 0.5 miles from the actual site.
Yes, from the actual site.
Site where the toxic materials were deposited.
Right.
Not
Correct.
from the front gate of Fort Detrick.
Right.
The actual site.
That's correct.
Okay. And is it easy to determine exactly where that 1/2 mile radius comes?
Yes.
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 So if I were going to buy a house somewhere near, the person selling me the house would easily be able to determine whether that house was located within the 1/2 mile or outside the 1/2 mile.
Yeah.
Okay. Do you happen to know how many of your constituents live within a 1/2 mile of the Superfund site?
Probably 2,000 homes, roughly,
Okay.
after the new additions.
Roughly 2,000 homes, but one of the reasons that this issue surfaced in Frederick to begin with, and it started out as a local bill, is that a couple of years ago, there was approval of a new development very close to Area B, and this is why it became a major issue. So 2,000 but growing.
Okay.
Because
Great.
Frederick County is the fastest growing county in the state.
Okay, I think you've answered my questions. Thank you very much.
Good.
Thank you, Mr. Chairman. Nice to see you, Senator. Yeah, I do remember this bill and the issues coming out of Frederick County. I looked up Superfund sites in the state of Maryland and Harford County. That's what I represent. We have one of 4 mega bases in the country, Aberdeen Proving Ground. Its history starts in 1917. It is purposefully where we test ammunitions, chemicals of all kind, and we've been cleaning it up for a long time. It is not a place that can be completely cleaned up, nor should it be. The cost would be prohibitive. It's better to let much of this just lay where it is. It is the size it is, which is 35,000 ground miles, 25,000 nautical miles, basically 30% of our county, maybe 20%. It was chosen for where it is. It was made large for what it does. So I have some heartburn about this bill for my county because I don't think it makes sense for my county. And I worked with my county, been there. I have not heard anybody with, in Harford County wanting this, but, or feeling that they are not well informed as it is. I'm also deeply concerned that the most adjacent properties to Aberdeen Proving Ground are areas that struggle mightily with bringing in, better schools, better housing. We are tackling a lot of issues. I'm happy to be there. I think it's the greatest part of my county, to be honest. I've lived there all my life, so has most of my family. So I work tirelessly with Southern Harford County, as we would call them, to promote my area, to make people want to come, live, love our area. I have a lot of consternation about what signal this would send, and that I don't think it would add to the general knowledge that we have in Harford County about Aberdeen Proving Ground. So I appreciate that you might have made it statewide, but I'm letting you know, and rather than debate it, what I would suggest is, now that you've heard me, I'm happy to talk to the senator sponsor later, and or anything you want to, send to me in writing about what I've just talked about, rather than take up this committee's time on this very one issue of Harford County and Aberdeen Proving Ground. So my recommendation is just get back in writing, but thank you.
I will say, I think you've just made the case for why we need this bill. You don't know what you don't know. And if people are not raising this as an issue, like I was never told, they need to be told.
Listen, I don't want you to start.
Okay.
My husband had worked on this for 30 years. His dissertation is on this issue, right? No, that's not what I was saying. I was saying the ubiquitousness of this, not only Aberdeen Proving Ground, but the knowledge of what they do and what is there. And I don't want to belabor it. It is we know what Aberdeen Proving Ground is. I don't believe it will have any added benefit relative to the harm that I think it could cause in the area that we are trying to redevelop, that is not in any way being harmed by the reputation of Aberdeen Proving Ground. There were other issues that came into play, but so I don't want you to mishear what I said, like, oh, none of us know. No, it's sort of like the most well-known thing in my county, but
we can talk off.
So we'll talk offline. That's what I really wanted to say. Thank you, Senator. Thank you.
No, that was great. Thank you very much, Senator James. That's very good. Okay, we are now going to be joined by 3 witnesses who are coming in, 4 now, by Zoom. And I'm certain that there are no other witnesses in the audience that are here to testify favorably. Okay, so we're all ready to go with the Zoom folks. All right, let us hear from. So is John B here?
Yes, I am.
I'm sorry. We'll hear from you first. You're and if you're on, if you could mute like Jen. Yeah, thank you, Jen. Mr. B, you're up.
Yeah.
There's one other person that's.
One person or one.
Oh, okay, Mr. B, if you could turn if you're listening to us on YouTube, if we could just mute YouTube or close that out, and then we're ready to hear you.
To start to address some of the racial inequalities that we see in Maryland prisons.
Mr. B, if you could, all right, here's what we're gonna do. Mr. B, let's go on to Ms. Hahn, you're up.
Hi.
Hey, welcome.
Thank you. I grew up near Fort Detrick. My elementary school was across the road from Area B. I grew up playing in the nearby seeps and springs. Fort Detrick suspected contamination from Area B's unlined landfills had traveled off-site through the groundwater, and in the 90s, one of those springs that I played in as a child was tested for contamination. They found large amounts of TCE, a known carcinogen. When I was 12, I was diagnosed with Hodgkin's disease. When I was 31, I was given 8 months to 2 years to live. And when I was 37, I had breast cancer. In 2010, I asked my friends on Facebook who went to elementary school in the 70s and had cancer before they were 25, or knew a classmate that had died young from cancer. I had 24 responses in 2 days. We had never been told there might be a Superfund site on the national priorities list near our homes. We wouldn't have played in the Springs. I decided instead to point my effort, instead of spending decades to prove a cluster, that my efforts would be better spent trying to help this not happen to anybody else. This is what has brought me here to you today. Without this bill, current and future homeowners are not entitled to adequate disclosure that may alert and educate them to potential vapor intrusion and other contamination risks from nearby Superfund sites on the NPL, which the realtors, by the way, have missed. They're just talking about Superfund sites. Two different things. TCE has a maximum contaminant level of 5 parts per billion. The Army found levels of TCE along their fence line at 15,000 parts per billion. 1 foot on the other side of this fence is owned by a developer who was approved to build townhomes by our local planning commission before testing was completed. Because the remedial investigation by the Army was not complete, which, by the way, the developer delayed by denying right of entry, and because the Army had stated no risk because no homes were there yet, so there were no people to be exposed to at the time, the Planning Commission said its hands were tied to deny the development. Is that my 2 minutes?
Yes, Ms. Hahn, if you could briefly conclude.
Okay, a decade later, we now know that the last set of data confirmed that there is a vapor intrusion risk for some of those homes. What we do know is that those homes will be built. What we don't know is how this information is legally mandated to be disclosed and explained coherently to current and future home buyers. As written, the realtors' amendments have obfuscated this intent.
Thank you very much, Ms. Hahn, and thank you for sharing your story.
I can answer, by the way, please, a lot of the pointed questions I can answer in 1 sentence if people have them.
Excellent. Thank you very much, Ms. Hahn. We're now going to move on to Ms. Kuntz. You're up.
Yes, thank you.
There you go.
Okay, there we go. Thank you very much. Yeah. Oh. The host keeps muting me and unmuting me. Okay. My name is Jennifer Kunze. I'm the Maryland Organizing Director at Clean Water Action. And like Jen Hahn, I grew up near Fort Detrick, although a different part of the fort, not on the NPL site. And I want to emphasize that sites on the NPL really deserve this special consideration for the surrounding community's safety. These are EPA's list of the most hazardous sites in the country identified to be eligible for federal funding to pay for extensive long-term cleanup actions. And the half-mile radius is very important to be protective. Something that happens as NPL sites are being investigated is that the area that is understood to be contaminated can change. And so the half-mile radius around the NPL site is important just so that potential buyers have that ability to know and do their own research and make an informed decision based on the facts. And that half mile ensures that it is based on an estimate of HUD's, the Housing and Urban Development Proximity to Superfund Sites guidelines, and it's well based in the research. I also want to, just to answer the senator's questions earlier, this is specific. The Fort Detrick is a large campus and actually have several campuses, but what's on the NPL will be specific to the site of contamination. So for Fort Detrick, that's Area B groundwater technically. Specifically at Aberdeen, for example, there's 2 specific locations that are actually on the NPL, not the entire campus. And finally, this disclosure that's very specific, pointed about the location, specific to the homes in that location, and clear and stands out, very important so that buyers are well-informed and can make well-informed decisions for themselves.
Thank you very much, Ms. Kunze. We'll now hear from Ms. Gabase.
Hi, thank you. Hi, my name is Jessica Grace, and I'm with, I work in environmental health and safety. I specifically work in industrial hygiene. My background is in chemistry, and I'm here as a constituent to support this bill, disclosing the hazards that are known to be present at Superfund sites to adjacent home purchasers. These hazards move through the soil and encroach on private property. A quick lesson in safety: hazards and risks are different terms. A hazard is something that has the potential to cause harm, and we cannot change that potential. And a risk is the likelihood that that harm will come to pass from that hazard. We can control that risk. because we can control likelihood. So for this bill, we are specifically talking about the associated risk with the hazards found in Superfund sites throughout Maryland. These sites have already been assessed and have been deemed hazardous to human health and the environment. And the simplest and most effective way to control the risk of these hazards is simply to inform purchasers that the hazard could be present, just as we inform purchasers of homes of many other risks hazards such as lead, radon, or asbestos. Lead, radon, and asbestos are residential hazards that are well characterized and have documented effective mitigation practices. It's my understanding that real estate law requires these hazards to be disclosed when known and that the hazards could be present. And despite the very compelling health hazards of radon, lead, and asbestos, people regularly purchase homes possibly contaminated with them. Informing purchasers of the hazards of the Superfund site reduces the risk that the hazard will cause harm. It will not stop purchasers from buying older homes or homes in Maryland where radon naturally seeps out from the earth. I sit on the Restoration Advisory Board for the Fort Detrick Superfund site, where groundwater is contaminated with volatile organic compounds. Volatile means it will travel through the soil and into basements in a similar path that radon would take. Radon is easily...
You can go ahead and briefly conclude.
Oh, thank you. Radon is easily controlled by vapor mitigation systems, just as the one I had put in my home recently. And it's a selling point. When I do sell my home, I can prove that my home is safe. And it is very well documented and understood that we can control these hazards or these risks if people are informed that they are present. Thank you.
Excellent. Thank you very much. All right. Now, Mr. B, we're going to try it one more time. You're up. Welcome back. I think you're unmuted and ready to go.
Can you hear me?
We can. Yes. Success.
All right. This is John B. I appreciate the opportunity to talk to the committee. I'm an environmental scientist. Had a career about 40 years long. I've included my resume and a brief of 30 pages to the committee. I hope you read it. Worked for Union Carbide and the US EPA and industry on about 40 Superfund sites that I can remember. Geologist, hydrogeologist, environmental scientist. So that's my resume. So over the last 40 years, I've cleaned up chemical sites for industry and the public. The bill we're considering covers only 20 listed sites in Maryland. It addresses the tip of the iceberg, only the Superfund sites, but it's a good start. I deal in my practice with underground tanks and spills from dry cleaners. Those are not covered by this bill. The bill should force realtors to inform buyers of environmental danger nearby. Simple as that. The research justifying half a mile is documented in the literature, but HUD and the EPA use 0.61 miles. So your half a mile is a good start. But I've worked on sites where the plume is 10 miles long. It all depends upon the hydrogeology. For sure, Fort Detrick in Maryland, their plume has crossed the property line. And Waverly View realtor bought property on the fence line. And their literature talks about how wonderful it will be to live in Waverly View, but not that 25 cows died on the property line of Fort Detrick, which shares a property line with their property. So if you're
Thank you, Mr. B.
I've met these victims.
Mr. B, if you could briefly conclude, your time's expired. If you could briefly conclude.
I support the bill.
That was the most powerful part of the testimony. Okay, that's great. Thank you very much. I appreciate it. Thank you for submitting
Thank you for your time and your consideration.
Thank you very much. Thank you. And thank you for submitting your written testimony. We will review it. Question from the committee. We have Senator Folden and then Senator Muse.
Thank you, Mr. Chairman. So I just I'm gonna ask you, the sponsor, a question in just a moment, but Jen Peppy, I'm sorry, wrong ones. Peppy, huh?
I'm nervous, Bill. Be easy.
I know you are. Hey, I need you to answer that question that was asked earlier in the sentence that you didn't get. I want to hear
Yeah,
what
and
you
I think
said.
this will also address the senator of talking about Aberdeen Proving Ground. The EP at our RAB meetings, the EPA said, how do you define that half mile? Well, within our bill, we give you a URL. If you all should try that URL as you're looking at this bill. Go to that URL, click on View Site on Map. There's a yellow line drawn around it. You can use your half mile from there. Better yet, you pick up the phone and you call the site contact listed there. And you say, I'm going to give you an address, enter it into your longitude and latitude. Let us know if this is within a half mile. The other way, I want to give you the definition of what defines the Superfund site. There's a source contamination always within these sites. This is the one sentence answer that's going to be 3. And then when it goes in a groundwater plume, here's the source contamination, and the plume can be miles long. Anywhere along those miles long, you take an 8th grade protractor, you put the point where they know there's contamination, and you draw a circle around it that's a half mile. Every one of those points is somewhere to measure that half mile from. And that plume or that mat, you can find that on each respective site on that search for sites where you live URL that we gave. I just want to say here that EMS site was stricken out of the bill last year. It should have never gone back into the realtors amendments this year. That is not the industry standard site that's public facing and user friendly to just distill and discern Superfund sites on the NPL. We have to remember that's what this bill is about, not Superfund sites and every bottle of spilled paint down your street.
Okay, thank you for your answer. And then the sponsor, Senator, I've seen the AG Consumer Protection Division in here like twice today. Was there any contact between you and the office with them as far as whether or not they would support or give an opinion on it? On this disclosure form?
No.
Okay.
No.
Thank you.
Thanks, but good suggestion.
Thank you.
Can I say there, because I'm still off mute, that in New Jersey, when a lady won a lawsuit for not being able to sell her home because she was never told it was near a NPL site, it was considered consumer fraud. It was taken up by consumer advocacy divisions in New Jersey. So that's a really good idea.
Can I say something?
If we ask you a question.
Can I say something?
If the senator wishes to hear, Senator Fulton still has the floor. If the senator wishes to hear from you.
Senator Fulton,
well,
can you ask me a question?
Yeah, go ahead, Mr. B. Yes, Mr. B.
Because is he your constituent?
No, Jen is.
But Jen is, right. Well, Jen, thank you for that. All right, Mr. B, let's keep it succinct, but go ahead. Senator Fulton, go ahead.
Mr. B, did you have something you wanted to comment on?
Yeah. This all came about when Jen got bent out of shape about Waverly View buying property on the border of Fort Detrick. And this applies to every site, every contaminant site. People should know what they're buying property next to. I develop sites that are contaminated. I clean them up. The first thing I do is check if there's contamination. It's for the protection of the realtors and the buyers of properties that they should know. So This is why I support this bill.
Thank you. And I appreciate that. And I know that this is actually just a notification. This doesn't have any penalty or consequences with it at this time, but there would be a large portion of homes surrounding this area. I'm very familiar with the Superfund site. I'm familiar with the homes that have been built there since our last hearing even. And I believe that there should have been some notification made there. So thank you.
Thank you, Mr. Chair, and to Senator Young, and then Mr. B and others who I recognize and I remember I guess it was 12 years ago, 16 years ago, we worked on the cancer cluster bill. And the
And we thank
example
you.
of that, yeah, thank you. The example of that was Fort Detrick.
Yes.
And building the development on sites that had been contaminated. I remember the testimonies of the farmers and their animals and everyone within a certain perimeter and cancer. And we got part of that bill through. And has anything changed with the Fort Detrick area that you know of? We had a cluster of pastors up there and NAACP and everybody who was screaming about it. And it sounds like we're right back in the same place in many ways, different place, different time, same issue, same arguments against trying to clean up the environment and protect citizens and putting that before money. And I know that's a tough battle to fight, but here we are fighting the same one because at that point, big money came in against the bill and said, we don't have a problem, we're fine, etc. And here we go, are in the same city, same county, same area, it seems to me. And all of the complaints are the concerns and realities are the same. Anything changed much since then?
Well, thank you for that question. I mean, in Frederick, you're correct. It's been a decades battle. There have been numerous champions along the way. Jen Hahn certainly has devoted her life to, trying to protect other people from not having to experience what she has experienced. So for those of us that have been in Frederick for a while, and I have some family members that have been there a long, long time, there was even a scientist at Fort Detrick decades ago that was a whistleblower on all this,
correct.
and he jumped off a roof.
And in fairness, there was a major remediation that was undertaken by the military, by the government, but it still doesn't negate the leaching that occurred.
No, it doesn't. And thank you, Ms. Hahn. Good to see you again. And
Thank you.
respond to that question.
Yeah, I
Respond to
really,
that
I would like to say, you asked what has changed. Today, we're changing it. That's why we're here. This is the first step. I've spent 10 years going to the Planning Commission and saying, wait, you haven't been to the RAB. They know this is contaminate. There's no inter-office communication between what these military installations and their contractors are saying in the local communities. And I followed this with every meeting for 10 years. Here we are back again. And I finally got tired of it and said, until there's a law, nothing's going to change. So this 10 years later is the thing that can be the first foothold into changing this. Thank you for asking that. No, nothing's changed. That's why we're here today, because we got tired of pleading the same case for 10 years, because you cannot rush a decade-long remedial investigation. You literally cannot leave any stone unturned when you're looking to see, is the contamination in bedrock? 5 years ago, they said there was no way it was on this Waverly property. We pushed, they tested. They said, oh, we suspected it all along and we found it. We got to get in front of the horse. Today, we start that. Please don't listen to the realtor's amendments. They will squash the entire intent of letting people just be informed. Thank you.
Thank you, Mr. Chair. Thank you.
Excellent. Thank you, Senator
Senator,
McKay.
thank you.
Thank you. Thanks. Thanks.
Thank you, sir. My question is for you, Senator, please.
Sure.
So in this bill, it talks about creating a website that will have people know where a particular site is. So my question is, how does that website, do you type in your address and it literally gives an approximate, or how interactive is that going to be other than saying an area? And I'll give you a good example. In Allegheny County, we can have an area called McCool, and that may be a more broader explanation of the area than it actually is in location to the Superfund for the site.
The bill doesn't create a website. The website already exists.
Okay.
There's been some question about which website to use.
Right.
And I have a panelist that's kind of an authority on the difference between the websites. But the realtors recommended using a website that's really in testing phase, that's not as comprehensive. And we are recommending a website that's been in existence and is recommended, and I believe managed by the EPA. So nothing new.
Well, and that sends a red flag up, because while this is something separate, but the federal flooding maps that the federal government sends out, I can tell you that the town of Midland, their city hall is in a floodplain.
Right.
And it's on top of a hill. So there's no way that federal government got it right with their maps. So what my only concern is that, yes, I want people to be informed of a particular piece of property, but I also don't want to overshadow saying that you're in an area because the map wasn't specific. And that's my only concern.
I'm going to defer that to Ms. Law, who is a scientist and an engineer and can speak to it more accurately.
Thank you.
Thank you. The EPA websites are continually evolving, and it's just like any bureaucracy. It evolves when there's pushback. And the basic way that the website we're recommending works is you just type it into Google, and from there you can search by county. And there's a list of things to look at. And one of the links is MPL sites. And you click on that, you put in, for example, Frederick, or just click on NPL sites in Maryland, and you will get a list of the NPL sites. And then at that point, you can click on that NPL site, it's the specific one, and find out what they do know. And as Jen Hahn said, there's a phone number of a local office, and you can call and you can say, and we haven't found anything as crazy and egregious as a floodplain at a mountain. But if you have a specific address and you call and you say, and they say, well, we think it's near such and such Aberdeen Proving Ground, and you say, yeah, but I'm 15 miles. My house is 15 miles from there, and then it's a corrective action. But the value of the website is that when a person is given the paper that says you are within half a mile, then they can go to the website and they can check out before they put down the final money to close the deal on that house that is the #1 investment of their lifetime. The other thing is the realtors who are the experts. Every realtor has their area where they sell their houses, and they know that area. They know who. Somebody walks in the door, they can say, I think we're going to send you over to look at these houses or those houses. They should know. It's part of being a professional for them to know the website and to use it and to keep track of things. It would be to their advantage if there's remediation and an area is taken off the NPL site. But it is also their professional responsibility, their ethics, to know their territory and to share that information with people so that people have like a lemon law. They have the right to know what they're walking into.
And I guess my only concern with it, and I appreciate that, is that technology is advanced enough. We Google fence all day long. Google fencing who's going to get a text message that you didn't want in the first place for XYZ political whatever, or somebody selling a sandwich that you didn't want. Mm-hmm. Google fencing for making sure that my children don't go outside certain areas with their phone. So to me, the technology is there to say this is exactly where the Superfund site is, and it's within whatever we determine is the fence.
Mhm.
And there should be a very, very easy way that we can then just click on and says, the address that you're trying to search that you would like
Mhm.
either falls within that fence or it doesn't fall within that fence. And I'm not and I granted that the realtor should be as professional as possible and know their areas, all that kind of stuff. But the reality is we don't buy cars when we go to the dealership as much as we do. We buy that from our phones. And any kind of a real estate transaction begins by going to Google and looking on a map and trying to figure out, I'm interested in that property or I'm not. So I would just say, Madam Sponsor, if you would consider that, I think that would be a great way to get my support. And I obviously have a super funding within my.
Yes, you do.
So,
Yes, you
you
do.
know, I applaud you for what you're doing. I think it's important, but I don't want to ruin the possibility of a piece of property that has not been affected,
Right.
but yet the concern that it may be in that area, and we have to then follow up and fix the town of Midland, who's up on a hill and they're in the floodplain. So thank you very much.
Thank
Let's
you,
work
sir.
together on this one. Thank you.
And with amendments there, Bill Castelli, William Castelli.
Thank you, Madam Chair, members of the committee, Bill Castelli on behalf of the Maryland Realtors. And we did submit some amendments. And let me just kind of boil down what our chief concerns are. As realtors, our concerns, we represent both the buyers and the sellers. Our buyer agents absolutely want their buyers to know as much information as possible. So if they're within 0.5 miles of a Superfund site or near a Superfund site, obviously those agents would want those buyers to know that. But we are also representing sellers, and the sellers have to have, with some legal certainty, the ability to know exactly whether their property, because you are asking the seller of the property under this bill to disclose whether that property is within 0.5 miles of that site. So if you're referring them to the EPA site and there's no easy way to measure 0.5 miles from the plume to their house. Now, I heard today that maybe you can call a telephone number if that can provide legal certainty to the seller, because there will be potential liability on that seller's behalf if they're not providing that accurate information. So that's why we've recommended it be a buyer notice. So then a buyer notice puts that buyer on notice that they are near a Superfund site. They can go up to the site. If they're 0.5 miles away, they can investigate it. If they're 0.6 miles away, they can investigate it. You're not just limiting it to buyers within that envelope of 0.5 miles away, because someone who's 0.6 miles away may want to know that they're buying property near. But it puts the onus of investigation on the buyer because of our concerns about whether the seller can, with legal certainty, provide the notice that is required under the bill. I'm happy to answer any questions if anybody has any.
Questions? Thank you very much.
Thank you.
There is no one signed up unfavorable to this bill, so that concludes the hearing on Senate Bill 125. Next up, we have Senator West, Senate Bill 147.
It's a pleasure to be here. Thank you, Madam Chair. Pleasure to be here to present Senate Bill 147. And I have Michelle Siri sitting next to me. She's the current executive director of the Maryland Legal Services Corporation. She's here to answer questions. This is a very, okay. And we all know the guy to my right. This is a very exceedingly simple bill, and hopefully the hearing will be far shorter than the last hearing. So Each year, the state budget for the last several years has contained a notation requiring the Maryland Legal Services Corporation to report quarterly various statistics relating to the Access to Counsel in Evictions program. The purpose of this bill is to simplify this reporting requirement. It puts the reporting requirement into statute rather than requiring the reporting language to be annually inserted into the state budget. Furthermore, it reduces the frequency of reporting to annually instead of quarterly. So late last week, I spoke to Michelle Siri, and she confirmed that the Maryland Legal Services Corporation already reports the information required by this bill, but she reports it quarterly. She noted that the MLSC budget is only funded through June 30th, 2027. So there is an expense associated with providing these reports. And she said that the MLSC would not be able to prepare the reports if the funding should be significantly reduced. So for this reason, she asked that I amend this bill to sunset the bill as of June 30th, 2027. I was happy to accommodate her request, and you should have an amendment to the bill, a friendly amendment that I've prepared in your packets. And with that, I appreciate the committee's consideration of the bill and will be happy to answer any questions that you might have. I think maybe Mr. Wiggins would want to say something. And Michelle is sitting here to answer questions if you need them.
Good afternoon, Madam Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Multi-Housing Association. We are in full support of the bill. We thank Senator West for bringing the bill forth. We think that the reporting is a critical component in the evaluation of the program. We're using state dollars for the program. And as he noted, instead of it being included in the JCR report every year, this will just codify it. And we have no problem with the amendment that's offered by MLSC. Thank you.
Madam Chair, would you like to hear from me? I was just here informational. Okay, sorry. Good afternoon, everybody. Michelle Siri, Executive Director of the Maryland Legal Services Corporation. As I stated, thank you to Senator West for putting in the amendment for our bill, for this bill. We have no opposition to it. We are already reporting all of this information in 3 various different formats through the annual ACE report to the governor, through the JCR report quarterly, and then also as part of the Access to Counsel and Evictions Task Force, which just released its, I think it's a 60-page annual report. So all this information is coming out there. We have no opposition to including it. And simply the budget issue is that the funding for ACE is currently only set through fiscal year 27. Now, I did suggest to Senator West that he could just extend that indefinitely, and then we wouldn't have to put the opposition or the sunset for the reporting. But I guess this is a little bit cleaner this way right now. So, but I am here for any questions that you may have. Thank you very much.
No one has signed up in opposition, so thank you very much for your brevity, Senator West. We'll consider that. Give you some points later. Next up, we have Senator Sidnor. You have 2 bills, Senate Bill 57 and Senate Bill 19.
Good afternoon, Madam Chair and Committee. Senator Charles Sidnor here to testify on behalf of Senate Bill 57. This is a reintroduction of a bill that we heard last year. And if you all remember, the reason that this bill was put forth was to help to address a problem that we have within the state of Maryland and have across the country, which is ensuring that people are not discriminated against as they look for housing. Senate Bill 57 provides for the use of electronic surveillance as an evidentiary gathering technique to protect against housing discrimination. This testimony will provide why Senate Bill 57 is necessary for the protection and security of our constituents' civil rights. Senate Bill 57 adds an additional limited exception where the interest of justice requires that the interception of wire, oral, or electronic communication. As reported by the National Fair Housing Alliance in 2023 Fair Housing Trends Report, there were 33,007 fair housing complaints received in 2022, the highest number of complaints ever reported in a single year. Overall, complaints were at 5.74% higher than the previous year. Complaints were based on source of income and domestic violence increase. Even with this record-setting number of complaints, most incidents of housing discrimination go undetected and unreported. To help address these unfortunate trends, Senate Bill 57 is intended to strengthen federal and state enforcement of fair housing laws by exempting from the scope of the state's wiretapping statute work performed by authorized fair housing testers that have been trained. Fair housing testing refers to the use of testers who, without any bona fide intent to rent, sell, or purchase property, pose as prospective renters or sellers or buyers of residential real estate for the purpose of determining whether housing providers and others are complying with the Fair Housing Act and similar state laws like those we have within Maryland's civil rights provision. In 2021, the United States Department of Housing and Urban Development built upon existing law through its affirmatively furthering Fair Housing Act, which amended the prior Fair Housing Act of 1968, requiring program participants to proactively take meaningful actions to overcome patterns of segregation, to promote fair housing choice, eliminate disparities and opportunities, and foster inclusive communities free from discrimination. Those program participants are generally your local and state governments. That's why if you look at your packet of testimony, you'll see I believe most everybody here would have had their government, local government supporting this legislation. While Maryland has very stringent housing discrimination laws in place, documenting discrimination and gathering evidence in action has its barriers. One of those barriers is our current limits of Maryland's Wiretap Act. While federal and state law in many states allow a single party to a communication to record the communication without the knowledge or consent of the other party, Maryland is in the minority of states who do not. Senate Bill 57 does two things. First, Senate Bill 57 introduces and defines the term nonprofit civil rights organization, but limits the kind of organizations that may qualify as nonprofit civil rights organizations under the Maryland Wiretap Act to either a qualified fair housing enforcement organization or a fair housing organization as defined under a HUD regulation, or an organization that's incorporated in Maryland law as a private tax-exempt civil rights organization that has at least 2 years experience in complaint intake, complaint investigation, and testing for fair housing violations or enforcement of meritorious claims. The federal regulation, which is used to help define what a nonprofit civil rights organization is, comes from Part 125 of HUD regulations. It establishes that the rules around its Fair Housing Initiatives program. Under this regulation, testers must be trained. And I say that because you'll see in some of the opposition testimony, they say that these folk are untrained. That is not true. As I said, under this regulation, testers must be trained in testing procedures and technique. Testers are barred from having any economic interest in the outcome of the test and be a relative of any party in the case, have had any employment history or other affiliation within 1 year with the person or organization being tested, or be a licensed competitor of the person or organization being tested. Those are some of the limitations. Second, under this proposal, Senate Bill 57 also creates a narrow and limited the exception to the Maryland Wiretap for its specially defined fair housing testers. In sum, Senate Bill 57 would create the 12th narrow limited exception to the scope of the Maryland Wiretap Act, which already exempts other specialized persons for specific policy purposes. This amendment and narrow addition of actors accepted from the scope of the Maryland Wiretap statute is extremely important in helping to enforce our fair housing laws
not other for residents of Maryland, but also for the honest landlords and real estate professionals who do not discriminate, but are put at a competitive disadvantage by those who do discriminate. There are some qualified organizations that provide testing to root out fair housing violators, including Economic Action Maryland, who you will hear from later. So I'm not going to go into that mission. They'll talk a little about that. Senate Bill 57, as I noted, would give nonprofit civil rights organizations the reliable evidence needed to successfully help upholding up our fair housing laws. Due to the nature of our all-party consent laws, fair housing testers are prohibited from recording their conversations during their testing and using the recording as evidence. This presents a tremendous hurdle in the effective enforcement of discrimination cases, making fair housing law nearly impossible to enforce. To help cure such deficiency, Senate Bill 57 incorporates the use of audio recordings in the fair housing testing, providing the documentation needed to prosecute discrimination cases, ensure Maryland's housing marketplace is free from discrimination, and residents and honest merchants alike are not harmed by those who seek to discriminate without review. According to HUD, and based on its experience investigating fair housing complaints, testers today generally audio and or video record their testing experiences, meaning that the recordings, not the tester's testimony, are of the utmost importance in most fact-finding hearings. Recording fair housing tests has become ubiquitous as cost of devices and technology has gone down, and the utility of such recordings has become evident. In many cases, sharing recorded evidence of fair housing testing facilitates early resolution and settlement. That's a big deal, negating the need to interrogate tester incredibility. And in the housing discrimination cases that go to trial, the main role of the tester as witness is to introduce recorded evidence of the interaction, not to recount their experiences in detail. In short, testing evidence often speaks for itself, and a tester merely needs to be credible enough for the judge or the jury to believe that their testimony, that the recording being presented is an authentic recording of the event at issue in the case. In closing, he came in right on time. At the end of last year, Frederick County pledged to help 28 households work with the Maryland Commission on Civil Rights to investigate claims that housing voucher recipients were charged more than other tenants in the same complex. One can only imagine the strength this case would have if a nonprofit civil rights organization's testers, equipped with the tool provided under this legislation, would have experience such as an act that the apartment complex is accused. This legislation is needed here in Maryland, and the time was yesterday. For the aforementioned reason I provided, I implore you to vote favorably for Senate Bill 57. And what I had also wanted to point out, just for your case, the Maryland, or while we have some opposition from multifamily folk, note that Maryland realtors are on board with this legislation because they know it's the right thing to do. And I want to point you to the testimony of Fred Freiberg, who was a fair housing practitioner, has over 48 years of experience, and also worked with the Department of Justice's Civil Rights Division in order to put their program together. The other thing that I wanted to point out, because when looking at the opposition, MMHA talked about the constitutionality and privacy. Last year, for all of you, I believe I provided a letter from our Attorney General's office that talked about the constitutionality of the law. There is nothing unconstitutional about this. As noted in my testimony, we're in the minority. Most states do this. So there's nothing about the Fourth Amendment constitutional rights that are being violated under this law. Additionally, in my testimony, and again, I mention this because MMHA talked about training. You're trained, you're highly trained. I used to do this. You go through a training on how to use these devices. RMI, they spoke about this being the first time that takes electronic surveillance out of the realm of criminal law enforcement. And he talked about no training. Again, these folk are trained, number one. And number two, the enforcement of civil rights laws. While I'm talking about a civil matter, violating those laws is also a criminal matter. So nothing's been taken out of the criminal context. So with that, I rest. I have witnesses here who will be testifying. So I'm going to be quiet. So, Marceline.
Good afternoon, Chair, members of the committee. My name is Marceline White. I'm Executive Director of Economic Action Maryland. Economic Action works on economic rights, equity, and housing justice through research, education, and direct service. And we're here in strong support of SB 57. And I want to thank Senator Sidner for bringing it forward. I'm here today because SB 57 represents the best opportunity to enforce and strengthen fair housing in Maryland by creating a very narrow exception to our two-party consent law. In October 2020, this body passed the HOME Act after many years of work. And shortly thereafter, my organization, Economic Action, began testing to see if there was discrimination around the HOME Act. Over the past couple of years, we've done about 50 fair housing tests around the HOME Act to see, as well as other kinds of fair housing discrimination. But we're hampered in that because we do not have, we have this two-party consent, this all-party consent rule. So it makes it more difficult. We have to use two testers or three for every test we conduct. In 39 other states, they just use a recorder. So we are hampered in this. I want to say why we support this law. It strengthens testing. Audio recordings provide incontrovertible evidence. That's why they are recommended by HUD. It protects testers and housing providers. So you can make sure there's not implicit bias by either or faulty memory. It's an efficient allocation of resources. We get funding from the federal and county governments, so we can use them more efficiently and effectively by husbanding our resources by using one tester as opposed to 2 to 3. And there is no right to privacy, which is why these commercial conversations are not protected and why HUD recommends using this model. For all these reasons, we support this legislation and ask for a favorable report. Thank you. Happy to take questions.
Good afternoon. I'm terrified of this clock. Okay. My name is Asha Smith, and I'm Anne Arundel County's Director of Equity and Human Rights. Anne Arundel County strongly supports Senate Bill 57. As a recipient of federal housing funds, Anne Arundel County is obligated to enforce fair housing protections and to affirmatively further fair housing under the Fair Housing Act and Maryland law. This bill provides a crucial mechanism for us to fulfill these mandates. I've personally investigated scores of fair housing complaints and can attest to the difficulty in proving violations. I've investigated complaints in a one-party consent state, and the ability to record fair housing tests is an invaluable tool. Victims often perceive that they've been discriminated against, but are unable to produce concrete evidence of a perpetrator's motive. Property owners and their agents are in sole possession of the evidence that a victim might need to prove their case. Chief among these is comparator data. How does the owner or agent treat prospective buyers or tenants who are not in the alleged victim's protected class? There's no way for the average victim to know. Fair housing agencies support victims by conducting investigations and conducting tests. In regions where recording is allowed, it generally occurs in 2 ways. First, a victim may allege that an owner or agent denied them housing because of their protected class, such as a disability. An agency tester can call the provider on a recorded line and say, for example, I'm interested in renting an apartment, but I have a service dog. Do you allow service dogs? If the provider says we don't allow animals, the agency now has recorded evidence of the violation to allow them to negotiate a resolution that will quickly get the victim into an available unit. Without the recording, a provider gets to say, prove it. By the time the case gets to a hearing and a judge has to rule on a he said, she said case, the apartment will be long gone and that remedy might be foreclosed. And so the provider may evade justice altogether. I knew the 2 minutes was going to go. I'll conclude by saying that passage of this bill would make our taxpayer-funded efforts to deter illegal housing discrimination significantly more efficient and effective. And accordingly, we urge a favorable report. Thank you.
Yes. Sorry, good afternoon. I'm Jonathan Smith. I'm the Chief of the Civil Rights Division of the Maryland Attorney General, and I'm on day 30 of the job. So I want to thank the committee for the support that you provided in the creation of the authority of the Attorney General to enforce the civil rights laws of Maryland, and this opportunity to appear before you today in strong support of SB 57. The state of Maryland and the federal laws, there's extremely robust protections against discrimination across a broad set of domains, yet discrimination continues to persist and be a very serious problem in the state of Maryland. The ability to test to determine whether or not discrimination is taking place is a robust tool that goes back to Dr. King's work in Chicago in 1966. It's been recognized for more than 40 years by the Supreme Court as the best evidence of housing discrimination. And I have worked in the District of Columbia and Virginia and in Maryland, where you can, in the District of Columbia and Virginia, where you have single party consent, where you can test, and the evidence that you can get when you can record is very different than the evidence that you can get when you have a tester who has to provide testimony. You eliminate ambiguity and you eliminate the opportunity for there to be disputes about what was or was not said. It is effective, it is efficient, and it is going to provide greater justice for people who are seeking a remedy for discrimination. Discrimination has become much more subtle than it was 50 years ago. People no longer post a sign that says Black people can't reside here. It's often in the form of steering, where a white person will be told one thing, a Black person will be told something else. Somebody who has got a service animal will be told one thing, someone without, someone who is LGBT will be treated one way and not another. And you cannot get to that discrimination without the ability to do this kind of testing. And the best evidence that you can use is if there's a recording. So thank you very much for allowing me to speak today.
Questions in the order that I saw the lights. Senator Dool, you had something else you want to say?
You know, and I forgot to mention, I do have an amendment that the Office of Public Defenders had looked at, that I'll be sharing with the committee, that limits any recorded information from being used outside the housing context. So just meant to mention that.
Thank you very much. The order that I saw was Senator West, Senator Folden, and then Senator Kelly.
Thank you, Madam Chair. Mr. Smith, could I have a conversation with you? I understand you're new at the Office of Attorney General,
Yes.
but you are familiar with the Fourth Amendment.
Yes, I am.
Great. Would you please explain to me why this bill doesn't violate the Fourth Amendment? It seems to me, as I read the bill, it permits the state, Baltimore County, or any other local government and private organizations to, without seeking a court order, to wiretap people and to discover during the course of the wiretaps that they're engaged in extramarital affairs, that they're planning to cheat on their taxes, that they're engaging in other criminal activity. And there's been no court order, no finding of probable cause. So please explain to me why this bill complies with the Fourth Amendment.
So the Fourth Amendment protects against unreasonable searches and seizures.
Right.
If you
We agree on that.
I'm sorry, we agree on this foundation.
Yep.
And so the question here is whether or not, if you're engaged in a conversation with someone and you say something, whether that is a search or a seizure for the purposes of the Fourth Amendment.
If somebody's wiretapping, so you're talking to someone on the phone thinking, I believe you have a reasonable expectation of privacy when you're talking to someone on the telephone, correct?
So,
and you now in the course of your conversation discuss the extramarital affair you're having, or you're plotting cheating on your taxes.
So
Go ahead.
This bill doesn't, it addresses a very narrow exception for the purposes of determining or not whether there's discrimination.
But how do you stop? How do you stop that? Once you're on once you're wiretapping someone's phone,
but it's
the wiretap doesn't click in the minute they start to talk about violating the fair housing laws. It is there regardless of what they're talking about. Isn't that correct?
I think, no, I'm sorry. You are, in lots of the wiretapping rules, and I've been handed some exceptions here, and rather than try to read it, the wiretapping rules are a combination of state law and Fourth Amendment jurisprudence. The protection,
the Fourth Amendment takes precedence over contrary state law, correct?
That is true, but the state law is much more restrictive. This particular state statute, the Maryland state statute, is much more restrictive than what the Constitution requires. Most states, and
this is more restrictive. As I read this allows private organizations to wiretap people and listen to whatever they say on the telephone,
and that is
irrespective of whether they're talking about violation of fair housing.
That's the law in most states that have been upheld by courts.
Could you provide me the citations of federal courts that have upheld
we can provide
these violations?
Yes, we can provide those citations. Yes,
I would love to see them.
Yeah.
All right, if I may read from the advice letter that I received from our office, it says, and it's talking about, it says these exceptions to the federal restrictions involving a warrantless interception by a party to the communication known as one-party consent to such an interception have long been upheld by the courts as constitutional.
We're talking about two different things here. One-party consent means when you're on the phone with me, without my consent or knowing you're doing it, you can record what we're saying. That's one. In Maryland, we have two-party consent. I have to be informed that you're recording it for you to be able to do it.
This bill is attempting to create. The state of Maryland has created the two-party consent. This is attempting to create or put us on the same playing field as the other states that are one-party consent.
As I read
this
the
narrow
bill,
exception.
it goes well beyond one-party consent. It doesn't say one-party consent.
Sure it does.
It says it's lawful under this subtitle for a person to intercept a wire, oral, or electronic communication, period. So it permits wiretapping of someone who doesn't know they're being wiretapped.
Sure, the tester knows. That's one-party consent.
And you're saying that's consistent.
I'm saying that the court says
that's consistent with the Fourth Amendment.
The U.S. courts say it is.
Well,
that's why again, Maryland is in the minority. Most states allow this.
All right, I need to read the decisions that you have. That you can cite to me.
I'll share it with you.
Thank you.
No worries.
Thank you, Madam Chair. So, Senator, I appreciate you bringing the bill forward. Why not just go ahead and do like
your bill?
Pardon?
Do your bill?
What you say?
I said, should I do your bill?
Sure.
Go ahead.
So, why not just do what is required of law enforcement and just get a judge's a warrant action for it? I mean, why not instead of creating a one-party consent, why not create an opportunity that these highly trained fair housing people have the authority to go and request a warrant with a judge?
So are you would that essentially be deputizing? I mean, how does that work?
The AG, look, the AG writes all kinds of opinions I don't agree with. I'm sure they could figure out some wordsmithing there to create an opportunity for them to be able to move forward with something because of the consequences associated with these fair housing issues, that while we're not going to violate two-party consent, we're going to require them to follow the rule of law that is in place for others that would request the same thing.
again, the ruling that's being followed is been established by the United States federal government. You have HUD rules and regulations that are put in place that these fair housing testers would have to then meet in order to do what we're talking about them doing.
Okay, so we're not going to agree on that they should get a warrant like law enforcement is. You know, law enforcement's entrusted with the responsibility of taking away someone's freedom, you know, and requiring them to follow these rules to the letter of the law. But we're going to soften the rules for this fair housing issue.
If I'm not mistaken, and I, because when the federal government.
And then my next question is, you know, what's to stop it at this point to saying, well, you know what, we have concerns about members of the clergy, of the cloth.
That's
and
not
we want
this
to
bill,
open,
though.
but we want to add them as a member that they can also be included in this.
So I know you have a bill that's going to be expanding some things with the wiretap law, correct?
That's for, for domestic violence and people in immediate endangerment.
So there are rooms for the wiretap law to be looked at and made and modifications to be made. I'm talking about one specific thing. I have no issue with the two-party consent. That's why I have no issue with the legislation that you're going to be testifying on. In fact, I asked to be a co-sponsor to your legislation. This is another exception because of the type of discrimination that's happening throughout the state of Maryland.
The difference being is one is an immediate threat to one's well-being, and the other is one that involves an investigation that could involve, and this is where I was going with this, why don't the AG's office, they like to have these opinions, they have investigators on these issues involving consumer protection, they've got investigators, why aren't they the ones sending in people undercover, under the warrant, protected properly to do this?
Because the way that the fair housing programs work, HUD sends money to the states. The states, they distribute it, if I'm not mistaken, to the local governments. Local governments, as well as state governments, are under an obligation, as mentioned earlier in testimony, to help affirmatively further fair housing. Government agencies generally don't have the staff to do it. Like, for instance, I had an opportunity to speak with your investigator up in Frederick County. It's an office of one person. He can't do what needs to be done. So what happens? These local offices, they hire organizations to go and do it.
But I'm not talking about HUD. I'm talking about the AG's office. Why not have a part?
I can't speak
the AG adopted. He wanted a lot of authority last time. He wanted the authority to take away the authority of the state's attorney's offices to investigate police shootings. He wants to add all these different departments. Why wouldn't he expand it to do this? This is something that's clearly an issue. So why wouldn't he want to expand his authority to do that, instead of allowing people that are not sworn and not going to follow properly vetted processes?
So let me make sure that I'm understanding. You're asking for an expansion of government when I'm talking about something that private industry does?
What I'm saying is that the AG has taken it upon himself to expand in ways that I do not agree with. But if he's going to do that, why wouldn't he take on this responsibility also? He seemingly likes to take on extra responsibility.
Because the idea didn't derive from him, it derived from me in a conversation that I had with someone else.
I bet if you had that conversation with him, he'll have a bill here for you next year.
We'll see what happens. I hope he wants to be it next year. Hopefully we can get this one passed.
Yes, sir.
My man.
Actually, Senator Sidner very effectively answered my question earlier, and I love his bill. Thank you.
Thank you.
Thank you. Thank you. I appreciate you bringing this bill, and I get the problem, and I know can be subtle, right? But you hear the concern, and Maryland has remained a two-party state for a reason. And what I'm wondering a little bit, following up on some of the other questions, is, we opened the door here, and I wanted to be the fly on the wall as a lawyer to so many things that I am certain a defendant has been engaged in, but I can't, right? That I can't be that fly on the wall. I can't be that person. I really hear some solutions in these questions that, for example, what Senator Folden was talking about, which, yes, it will take a little more effort for the bill and for you all, but it would then, I think, bring about some confidence that all the policy reasons why we remain a two-party state, and given that and correct me if I'm wrong, we're not dealing with criminal conduct. I think it is.
Actually, that's not the case. This is criminal conduct.
Well, I was going to ask you
This
that.
is
Are
criminal.
these
It's civil-
crimes?
It's civil and it's a crime.
So it is a crime?
Yes, ma'am.
Okay, well, if it's a crime, then I'm,
However,
really think that,
however,
if it is a crime, then I do think that's even more the reasons, given all the constitutional protections we afford people, all the more reason that we have a very good system. I'm happy to work to make that system better for this particular concern, but I feel like maybe we could find some middle ground because I don't want to lose. I don't think the state of Maryland wants to change its two-party system, its history, what it's worried about. So that's just a suggestion, but I'll ask you a question, Senator. So it is a crime. I didn't know that. I thought it was civil. I thought you penalize it, certainly. I did not know it was a crime in the criminal code of Maryland.
no, it's not a crime in the criminal code of Maryland. It's a federal crime. But what I was gonna say, and I believe
I need to clarify
Miss
that.
White, she touched on this. When you're dealing in commerce,
right?
Because when multifamily folk are selling or renting places, and again, everyone's talking about some expectation of privacy. That expectation of privacy is not the same as what it would be if you're dealing in a private person-to-person matter. That's not the case here. We're talking about commerce. And when it comes to commerce, some of those expectations, they go out the window. They're not the bar is not as high.
Please share whatever cases talk about that, because I wasn't aware of that either. I don't know a lot about criminal law. So if there's a demarcation between commerce and non-commerce in this context, I'd be very interested. So are the inspectors or people that you would like to do this, are they in? So one of the several things they might be doing is bringing about evidence for criminal cases in this regard. Is that
For
correct?
violations of the Fair Housing Act.
Right. Yeah. Yes.
Sorry.
So they could be doing two things. They could be bringing about an investigation for crimes of the Federal Fair Housing Act and or bringing about evidence to support a Maryland civil violation. Is that correct?
Maryland law is stronger than the federal law
Okay.
in some cases, so they could say that there's a violation of the Maryland Fair Housing Act or federal, depending on what the findings were.
Would you, given the concern here, would you work with the idea of trying to come up with a way to retain our two-party and not have, warrantless, no third party overseeing this process? Would you work with us in coming up with a program that would give you more flexibility and ability, but also stay more consistent with how we do things currently? Bearing in, and I mean it, work with you to figure out, how can we help you, but also not just blow up their system, because it's going to be hard for us to turn to another entity with egregious conduct that some people would love to get reported.
Right.
And then we say, no, just in fair housing. And so that is, suddenly, what is it? The camel's nose is under that tent.
Right, right.
So.
Yeah, I mean, I think obviously, yeah. I mean, I think obviously it's, up to the committee to work on things, but I don't know if you want to.
It's okay.
Sure.
I didn't mean to put you on the spot. I
Yeah.
was just saying I think people would want to be helpful, but you hear, and I'm sharing that concern for changing this law in the way this bill is currently drafted.
So I think one thing to be clear about is, and I think we've gotten, because of the fact that we've got, it's over the telephone, often over the telephone, but sometimes in person, you could record in person, these tests, that there's a confusion that's been introduced into this conversation about whether the function of testing itself and the collection of evidence and what that evidence is. Right now, that evidence is currently being collected, but it's going to be used testimonially. And all this does, it doesn't change. The Fourth Amendment is not otherwise implicated here, because all it does is change what the collection of that evidence is, whether that's through the memory of a tester or whether that's through a recording. I've litigated these cases in Virginia and Maryland, and never seen the kinds of concerns that are raised and.
Are they two-party states? or
Those are
one-party states?
those are single party consent.
That's why you're
they're
hearing the
one-party consent states.
concerns.
And the Department of Justice has for now 40 years had a testing program in which in states where it is lawfully permitted, they record, they record those tests. There are very, very few, and the circumstances in which you can criminally prosecute are extremely limited. All these cases are resolved civilly. These are civil, and the purpose for which the Attorney General would be doing the testing, because our authority is to enforce the civil laws,
Right.
would be for the purposes of remediating the discrimination in the civil context. And all of the cases in which these organizations are involved are civil cases.
Well, I'm very confused because I thought I just heard the nice person here tell me that when they're doing this, they may be gaining evidence for federal criminal violations. And by the way, I think that's very possible, whether that's their intent or not, because
The civil, it's the civil laws.
Civil.
Yes.
But the AG
All
has
right.
now criminal prosecutorial authority after the bill they passed last year.
but
Not over fair housing laws. Not over, that still remains with the state's attorney.
Oh, can you bear with me while I quickly read this amendment?
Sorry.
Okay. Can I ask a quick question, Senator? Senator, I appreciate this. It says, though, it may only be used for purpose of enforcing federal, state fair housing laws and not admissible for any unrelated criminal prosecution. But I think that still means I have a question. They could be used for a federal fair housing criminal case. So we do have and listen, we have to deal in the possible here. And I understand that you may not be interested in bringing the criminal matters, but you're clearly gathering evidence, or could be, that would involve, and even the amendment, it would still be involved in and lay the basis for a criminal federal case. Or you know, rather than debate it, just get back.
I'm unaware of the federal criminal law that would be enforced here. Now, I'm not saying that it doesn't exist, but I am unaware of what that law, that statute would be. And I don't practice, I've never been a prosecutor, so.
Me either.
So I've always been a civil, enforce the civil laws. I'm unaware of the federal, and there are thousands of these cases brought around the country every year on the civil side that using testing evidence. And just to emphasize that here, the Fourth Amendment implications of testing doesn't change between the difference between whether you're collecting the evidence through the tester or whether you're collecting the evidence through the tester's recording, because you're still collecting the evidence by the same means. Question is, how is that evidence being?
Well, right, but if you have a
recorded?
witness, you can cross-examine and determine their credibility. When you have a recording, there's a lot of other issues about the quality of the recording, whether it was manipulated in any way, and so on and so forth.
Well, certainly that's the whole deep fake thing, I think that's a problem we're gonna have to resolve in a different way. But a good example of how this plays out is that you have a testing organization. They call up a housing provider and ask the housing provider, say, I have a voucher, can I rent in your apartment? Person says no. They do that 3 times. They have 3 tests. They have 3 calls where where they get the same information.
Right.
If you have that recorded, there's nothing for the court to resolve in terms of whether the tester was denied access to that housing opportunity. Without the recording, you've got to put on those testers to testify, and possibly you've got a denial by the other side, and the court's got to resolve credibility.
Right.
So the Fourth Amendment issues are no different whether or not the person calls up and asks the question and then takes a note on it and it's in their memory, it reports it to their supervisor, or whether they record it. The Fourth Amendment implications are exactly the same. The question is, what's the best evidence? And the best evidence is the recording, so you can hear the person say, I have a voucher, can I rent? You can hear the person say, no, you can't. And sometimes there's and this is important for housing providers as much as it is for testers. Sometimes there's very subtle differences in the way it plays out. I can think of an example of a case I was involved in, and this was in DC, and we had recorded testimony where they called up and says, I have a voucher, can I rent? And they says, we're not set up to accept vouchers. Now, that is not a particularly effective test. You then have to ask, did the tenant say, well, what can I do to get set up? Or, how to test? And you ends up in these disputes that get resolved if you actually have the recording. And you can decide whether or not what actually happened and what was said actually was said. That is separate from the Fourth Amendment question. If you are concerned about the criminal piece, it doesn't really matter whether or not the tester's collecting the evidence by their memory. It's still evidence of if there's a crime, and I'm not saying there is, because I actually don't know of a fair housing crime in that sense, but we can research that question. But it doesn't matter. You're still collecting the same evidence. The question is, what form is that evidence being collected?
I think that's all helpful. And if it's not already in writing, please send it to me. But for any of you, and again, I get the issue. Okay. So, and I'm sympathetic to the issue, and I know it's become quite subtle. So, but again, two questions I have, with the camel under the tent and, I lost my train of thought. Hold on for a second. Tell me how, in the face of Maryland's year after year after decade after of resisting changing the two-party policy, principle, whatever you want to call it, why we should start now and do this in this situation. No. It's getting late.
Sure.
I thank you so much. No, you're really very helpful. Just come back to me, and the rest of us in writing would be super helpful.
Thank you very much.
Thank you.
Senator McKay. And then we're going to move on to the unfavorable panel. Wait to the next panel.
Thank you, Madam Chair. Senator, so these fair housing testers, how do I get an application? So my question goes along, how does that person then, are they certified? Is there some form of an oath that makes sure that somebody isn't becoming biased? Because I would think you would acknowledge it would be very easy, unless there are pitfalls, that somebody who is looking for to get the landlord, how do we stop that? That would be my first. How does one become a tester, and is there any form of certification? And
so a person typically applies for a job and is trained to be a fair housing tester. Depending on the organization that's doing training, they have their own protocols. I can tell you that I was a fair housing, well, I'm an attorney, but when I was doing fair housing testing, I was working as an attorney and also did testing for the New York City Commission on Human Rights, which was the law enforcement agency charged with prosecuting violations of the city's fair housing law. And I think that we've lost a little bit sight of the purpose of testing. We are not seeking here a carve out for the purpose of intervening on a phone call, right? The tester has two roles typically. Role one is where someone comes in and says, this bad thing happened with this specific person, and there's a unit and I need it and I can't get it. Most frequently, you find this with people who have disabilities. Accessible apartments are extremely hard to find. And so the immediacy, which the senator here was talking about, is really underappreciated. The goal is not necessarily to punish the landlord. The goal is to get someone into a residence. In a place where we have such a shortage of housing, especially for people with certain types of needs, it's critical. So what I would do as the tester is call that landlord and say, hey, I have a service animal. Do you have an apartment that I can rent? And if that landlord says to me, I don't rent to people with animals, we know that there's a violation. And this sort of evidentiary hurdle has already partially been crossed. We don't waste the time that goes into having to go to a hearing. We can actually present that to that landlord and say, hey, we have you doing this. It's a violation. If the unit's available, we're done with this. Get the tenant into the apartment. It's not about hearing about who's having an affair, and that's not how tests work. You don't open a line and sit on a call. What the other type of testing is audit testing, and that's probably more what you're talking about, where you train a tester, it's a pair of testers. Typically, they only have one difference between them, and that's a protected class. You train them, and there are protocols, and some organizations that do this testing actually have attorneys consult with them because they're looking for what's going to be admissible. The tests sometimes are very aggressively scrutinized in litigation. It's one of the things that you have to deal with when you go to court with some of these tests is how did you design the test? So there's a model that most of these agencies are going to use when they train testers to make sure that the tests are fair and accurate. But again, the goal is to get over this evidentiary hurdle so that we can move these cases and get people into housing. I hope that answers your question.
I can respond to if you want, Senator.
I would prefer to move on to the next panel. If there are no other questions. Oh, Senator McKay, you had another question?
I guess not.
No, you can go ahead. Okay. So that concludes the testimony of this panel. We have two people that have signed up for the other panel unfavorably. We have Aaron Greenfield and James Johnson.
Yes, good afternoon, Madam Chair, Mr. Vice Chair, members of the committee. Aaron Greenfield here on behalf of the Maryland Multi-Housing Association. We are in opposition to Senate Bill 57. You have our fairly lengthy written testimony that I know the sponsor cited. I'm joined today by Jim Johnson, the former Baltimore County Police Chief, who is here at my request. In a very unprecedented manner, this bill expands the wiretap statute to what we believe is a non-criminal context. Current law allows such interception as evidence against the person making the communication by an investigative or law enforcement officer or acting under the direction of one, and the target has to be alleged to have committed or be committing some type of crime and serious crimes as specifically enumerated in the statute. The wiretap statute is very explicitly intended to prevent in non-criminal situations the unauthorized interception of conversations where one of the parties has a reasonable expectation of privacy. And I would submit that housing providers do have a reasonable expectation of privacy. And the only way you can overcome that reasonable expectation of privacy is when you have probable cause that the person is engaged in the commission of a crime. This is typically done after some kind of background interviews, perhaps some background checks. Allowing wiretapping for fair housing claims might set a terrible precedent for expanding such surveillance powers to other contexts, potentially leading to abuse of those measures. Who is next? Who are next? Bankers, journalists, tax professionals, elected officials? Instead, let's continue to promote education and awareness programs for both housing providers and residents to foster a better understanding of fair housing laws and practices. For these reasons, the Maryland Multi-Housing Association respectfully requests an unfavorable report on Senate Bill 57.
Good afternoon, Madam Chair and members of the committee. As a 45-year law enforcement professional, former chief of a very large jurisdiction, state of Maryland, I urge you to give Senate Bill 57 unfavorable report. Maryland law enforcement personnel must conduct wiretaps or investigative recordings of another individual without their knowledge. To do this, they have to receive the equivalent of a warrant based on probable cause from a circuit court judge. Wiretaps are used by law enforcement in serious crimes such as homicide, kidnapping, and drug cases. They're not used as often as you might think, by the way, all right? Affidavits requesting oral intercepts contain exhaustive detail that you have to take to the judge, including sworn to statement of facts, details of the crime, descriptions of the device to be intercepted, the length of time that you can conduct this interception. In addition, the history of the interceptions for that particular individual. And these details all have to include what you've done to exhaust other measures to gain the information that you're seeking. Judges must find probable cause to believe that the target of the interception has or is about to commit a serious crime. That's important because you're not dealing with oftentimes a hardened criminal when you've got these sorts of discrimination investigation type cases in housing. You're dealing with an 18-year-old out of high school that had maybe a week off of training, may have just misstated a policy or procedure of the company. Police personnel must go through mandatory initial and frequent retraining, participate in wiretaps. Equipment they use is governed by the agency. They have to be sealed, and the chain of custody is very critical. Safekeeping the chain of custody, make sure that evidence is not compromised. Thank you.
Senator West.
Thank you, Chair. Sir, question for you. My question goes on this chain of custody. While this tester may be asking you on service dogs, I don't see how this bill protects chain of custody on how that recording, could that recording been manipulated? Could that recording have been shortened up? Was there questions that were asked before? If I'm not mistaken, when you actually get a warrant and there are parameters that have those safeguards. Is that not correct? And this bill doesn't show a single safeguard that I can see. I inherently believe that this is not intended as entrapment, but it just sends to set people up. And we stand against that. So can you expound a little bit more on those safeguards?
I'm very concerned about the safekeeping of this evidence. Exhaustive effort is put into by law enforcement personnel and agencies to ensure that evidence, that piece of taped information is not compromised. Restricted areas, restricted individuals that are allowed access to that material. Very meticulous detail on who touched it, who looked at it, who may have manipulated that information. If you're going to use this information, you have to have the physical structure to safe keep it and guard it. Very concerned. It's a very good point. Very concerned about that.
Thank you.
Thank you, Madam Chair. So I've got a couple of questions. Let me talk to you if I could, since your testimony was entirely about the Fourth Amendment. Let me read the first part of the Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And it goes on to talk about the warrant requirement. There's nothing in there, is there, about criminal cases versus civil cases? Right?
No.
Are you aware of any Supreme Court case which holds that the Fourth Amendment only applies in criminal cases, and in the civil context, people can violate the Fourth Amendment as much as they want?
No, sir.
And let me go on to the wiretapping in particular. So we had the case of Katz versus United States in 1967, which dealt with wiretapping. And here's what the court held, quote, "What a person knowingly exposes to the public, even in his own home or office, is not a subject of Fourth Amendment protection." I'm going to go on, but let me stop there. So a couple of years ago, Maryland enacted the two-person consent rule. So if I'm having a conversation with you, that's two people in public having a conversation. I can't have a tape recorder in my pocket and record what we're saying because it would require your consent to my recording, correct?
That's correct.
I would have no problem if this bill said, got rid of the two-person rule and substituted a one-person rule when you and I are having a conversation and permitted me to have a tape recorder in my pocket and record you. That would be the one person, right?
That's correct.
And the Katz decision specifically says that what a person knowingly exposed to the public, even in his own home or office, is not a subject of Fourth Amendment protection. So the Fourth Amendment, is it not correct, would not speak to a decision by Maryland to allow a one-person consent to a two-party conversation, because that's held in public. The two of us, I'm talking to you, right? But the Supreme Court goes on. But what he seeks to preserve as private, even in an area accessible to the public, may be constitutionally protected. Now, if you and I are having a conversation on the telephone and we have no idea that someone is listening in, doesn't the Fourth Amendment protect our right to privacy to have that conversation unless what goes on in the Fourth Amendment, unless the warrant part of the Fourth Amendment kicks into effect and the person wiretapping us has gone to a court, presented probable cause, and obtained a court order to allow the wiretapping to occur. Isn't that your understanding of the Fourth Amendment?
I think you're pushing up against the Fourth Amendment with this particular bill.
Thank you. That's all I have.
Senator Sidnor.
Thank you very much. Chief Johnson, is that you?
I'm sorry? Yes.
That is Chief Johnson?
Yeah, Jim Johnson.
All right. Used to be the chief of Baltimore County's police department,
I
right?
served for 40 years, had the honor to serve the Baltimore County Department, 10 years as chief.
So you understand the Fourth Amendment pretty well, correct?
I understand that it will impact this bill, yes.
Are you familiar with the case United States versus White?
White?
Yes.
No,
United
sir.
States versus White, 1971 case.
No.
So within that decision, it was held by the United States Supreme Court. There was a decision which held that recording conversations using concealed radio transmitters worn by informants does not violate the Fourth Amendment protection against unreasonable searches and seizures, and thus does not require a warrant. Are you familiar with that case?
I have to read that case, but you said informant, recording an informant. So that means he's working with the law enforcement agency?
And in this case, testers are working with the government.
I don't know if that'd be applicable to this particular argument.
It's very applicable, and in fact, it's in this letter from the from our Attorney General's office.
I'd have to read the entire case, sir.
So I mean, and as was noted by our Assistant Attorney General, we're talking about the civil context here. So, and I believe he had testified that with regards to that, the Fourth Amendment is set to the side because you're dealing with criminal matters. But I just wanted to make certain that that was clear, since my colleague went on a strong statement about the Fourth Amendment, and like, so I'm done. Thank you. I rest.
Thank you very much.
Just one other to either of you. Thank you very much, Madam Chair. One, it's my understanding that this has already been allowed in many other states. Is that correct?
That's what the proponent's testimony was, but I would say that there's perhaps a difference, and I haven't analyzed those states, and that
So
those are
what-
one-party consent states versus we're a two-party consent state. And I think that's the fundamental difference. If the sponsor wants to change the two-party consent, then that should be what this bill does. But this bill seems to subvert the two-party consent system that we have in the state of Maryland. But I heard the proponent's testimony, but I'm not familiar with those specific laws in the other states.
Nowhere in this country is the model of this bill already in effect.
I'm not aware.
Okay, I didn't know that because I thought that that's what was said, and I thought that we didn't have that. Okay, that's correct. Thank you. Sure.
Thank you very much. All right. Seeing no further questions on this bill, we will move on to Senator Sidnor. You're up again. Senate Bill 19. And you have, do you have a panel?
Okay, very good. Then come on up. That is all right. How you doing? All right. Wasn't expecting the last bill to take as long, so I'm wondering if I'll just kind of cut.
You are not alone, Senator.
Oh my Lord. So Charles Sidnor here to testify on behalf of Senate Bill 19. Senate Bill 19 introduces a bill that's similar to 2023's House Bill 34, which passed the House but was unable to receive a vote from our committee. Senate Bill 19 requires district courts to shield court records relating to specified outcomes in failure to pay rent actions and prohibits landlords from increasing a tenant's rent following certain outcomes in these cases. These modifications I'll go into. I call these the FTPR actions, which are routine filings that typically do not result in eviction. However, these filings appear on tenants' consumer and rental histories, accessible by prospective landlords, credit reporting agencies, and other third parties. Under current law, regardless of the outcome of the case and without context of the situation, FTPR records are available for public inspection and reporting. This creates a barrier to future housing opportunities, as tenant records are tainted with a modern-day scarlet letter that scares off prospective landlords as credit scores plummet. The availability of this information in a public record appears in a tenant's credit history and can prohibit a tenant from securing safe, stable, accessible, and affordable housing in the future. This is especially true for renters belonging to marginalized groups. The effects can extend beyond housing instability, impacting access to reliable transportation, quality school districts, quality of life, and work opportunities. Black renters represent 18.8% of all renters, yet over half of all eviction filings are against Black renters. I'm talking 51.1%. These racial disparities, while varying by state, persist across income levels. However, low-income households are at the greatest risk of eviction. Of the almost 402,000 FTPR actions filed throughout Maryland in fiscal year 23, around 157,000 of them were dismissed, and approximately 18,500 evictions occurred. Presumably, the rest of the actions ended in default judgments, presumably possessory redemption by payment. Over 400,000 Marylanders, the majority of which likely redeemed possession by payment, have FTPR actions looming in their records, potentially interfering with their ability to find housing later in their life. This is not the precedent that we want to maintain. To help address these collateral consequences, we've introduced Senate Bill 19. So as noted in my introduction, Senate Bill 19 does a few things. One, it prohibits a landlord from increasing rents solely, and I say solely, because of a judgment entered against a tenant following an FTPR action. Under current Maryland law, within 6 months of a tenant participating in a lawsuit involving the landlord, a residential property landlord may not arbitrarily increase rents. Second, Senate Bill 19 requires our district courts to shield all FTPR records within 60 days of the final resolution of actions that do not result in judgment of possession, thus ensuring easier access to safe and stable housing, safeguarding a tenant's ability to secure future housing, and ultimately avoiding homelessness and promoting racial justice. Third, if this type of action results in a judgment of possession, the court may shield all court records relating in the proceeding on motion by the tenant if the tenant demonstrates by preponderance of evidence that either one, the tenant exercised the right of redemption and 1 year has passed since the judgment was entered, or two, the court determines that there is a good cause to shield the record. Thereafter, a court will be required to seal the record within 30 days after granting the motion to shield the record. Furthermore, under Senate Bill 19, shielded records may only be opened if the tenant requests or if the district court orders it because good cause has been shown. Senate Bill 19 also requires the judiciary to develop and publish on its website a form to help educate people regarding Section 8503 of this bill. Finally, to note, this bill would be applied prospectively. While there is currently no federal legislation mandating sealing eviction records, several states have passed legislation to shield these records. Indiana and Minnesota allow tenants to formally apply for the court to seal records following a court decision. Arizona, Indiana, and Washington, D.C. seal records when the court rules in favor of the tenant. California and Colorado automatically seal records when eviction lawsuits are filed. It is time for Maryland to follow suit. In shielding records of an FTPR action, Senate Bill 19 aims to preserve the ability of tenants to remain housed by reducing the loss of housing opportunities resulting from records that do not tell the whole story. As such, I implore you to vote favorably in support of Senate Bill 19. Thank you all very much. Next, I will have my panel speak to their expertise.
Good afternoon, committee. Catherine Davis, Pro Bono Resource Center of Maryland. I direct the Pro Bono Resource Center's Consumer Advocacy Project, which provides representation for tenants facing eviction in Baltimore City and Baltimore County. We began this project in 2017 and have since represented thousands of tenants in rent court, the vast majority of whom are there in failure to pay rent actions. The overarching goal of our project is to promote housing stability among low-income tenants, and we are in support of Senate Bill 19 because it will have a direct impact on this goal. Maryland, as you heard from Senator Sidmore, Maryland has one of the highest failure to pay rent filing rates in the country and an equally high dismissal rate. In the first 9 months of 2023, over 300,000 failure to pay rent complaints were filed in Maryland, and about 36% of those were dismissed. Perhaps because the tenants didn't owe the rent, they were no longer reside in the property, or they had an unlicensed landlord. Extrapolating, that's about 130,000 tenants each year who could benefit from this legislation by not having to worry that the mere filing of this failure to pay rent case, one that was dismissed in the end, could impact their ability to secure future housing. In addition, Senate Bill 19 will help tenants who owe some rent, but are able to pay shortly after a judgment is entered in court. 2 weeks ago, I was in court with a client who owed $250 on his rent. He had never been to rent court before and was planning to pay that Friday. So we negotiated a consent judgment with the landlord that included a stay, which gave him enough time to pay that $250 before the eviction process could take place. He asked me as we sat in court if the judgment would stay on his record, and I had to tell them that it would. So he looked at me and he said, well, I guess I just better plan to live here forever then. He understood intimately that the rental market is tight and that his chances of finding a new and affordable place had just gotten a lot harder, even though he knew and his landlord knew that he was going to pay that rent on Friday. In Maryland's tight rental market, tenants should not have to worry about this. Senate Bill 19 is in line with other laws, and we are requesting a favorable report. Thank you.
Madam Chair, Vice Speaker, Albert Turner of the Public Justice Center. We represent tenants in the city of Baltimore. Particularly, we represent many tenants in failure to pay rent cases. Last year, we worked with Delegate Hill on this bill. This bill, as originally drafted, was very much different. And with the help of Ms. Howard from MMHA, we and Delegate Hill were able to draft the bill that passed. And we're grateful that it's here in the Senate to be voted on. We request a favorable report on this bill. We view this bill more along the lines of, or in the same vein as an expungement bill. And so when you have like a null pros, those bills those null processes are expunged, or at the very least, they're shielded from case search. And that is essentially what this bill would do as constructed. After 30 days of a dismissal for failure to pay rent case, a shielding of that dismissal will occur. For jurisdictions that have failure to pay rent cases in case search, they will no longer be able to be searched. That's really, really incredible for a lot of tenants, particularly tenants who are dealing with maybe some miscommunication with landlords. I can't tell you how many times I have seen a tenant in court every single month, and every single month their landlord either doesn't show up or they dismiss because of maybe some miscalculation with the ledger, some miscommunication, or by the time the case has been heard, the outstanding amount has been satisfied. And so what this does is that it allows for a tenant to not be searched on case search and for 20, even 30 dismissals be public. And we would like that so that a tenant may be able to find alternative housing. And with that, we would request a favorable report on Senate Bill 19.
Thank you very much. Next up.
Good afternoon, Madam Chairman. I'm James Bell with Maryland Legal Aid. Maryland Legal Aid, as well as these other two organizations that just testified, handle housing cases in the state of Maryland. As these organizations, we are the boots on the grounds for these evictions, and we see them on a regular basis. And as everyone's touched on before, I just want to share a couple of client stories. I was in Howard County last Friday, for their failure to pay rent docket. Met a gentleman who seen there multiple times before. He got the flu 6 months ago, was out of work for a week. As a result, was a little bit behind on paying his rent. He pays it before every hearing. He knew to walk up there, talk to the filing agent. The filing agent said, yep, we got the money. Case got dismissed. He doesn't have one failure to pay rent case that you can find on Case Search. He has 5 now. And it's the same slightly late payment that got carried over month after month that he's now resolved. But he's going to run into the future problems of, can he move? Because it's not one failure to pay rent case, it's 5, and everyone was dismissed. And this gentleman's not alone. We know that from prior testimony, there was 130,000 of these cases last year that were dismissed. Not all of them were because they were paid. Some of them were for other reasons. But this is what resolves the issue for that gentleman. I had another case last year where the landlord didn't have a license, kept filing failure to pay rent cases anyways. Every single one was dismissed. And pursuant to Maryland law, my client did not owe the money because pursuant to Maryland law, if you don't have a license, you're not allowed to collect that rent. That didn't stop that landlord from filing, did not stop the court from hearing those cases, and everyone was dismissed. But that client still now has that black letter on their rental history because they chose to enforce their rights. And that's the goal of this bill, is shielding people from the issues that someone else created. Thank you.
Thank you very much, Senator McKay, and then Senator James. Oh, wait, were there any other, is that it for this panel? Senator Sidnor, is that it for this panel? Okay. Well, no, still stay for the questions. I just wanted to make sure there wasn't anyone else on the sponsor panel before we took the questions.
No, I'll stand, but if there's some expertise that's needed, I'll sit.
Thank you, Madam Chair. Thank you, Senator. So, through the testimony, one would think that this backlog of failure to pay rent is nothing more than just landlords using that as a tool. I don't know for what. I don't know what violation is to actually get your rent paid. We in the General Assembly passed legislation that requires a 10-day notice for an intent failure to pay rent. I really just don't understand if the rent, you signed a document that said the rent was due on, you picked the day, and the next month, the rent on that day, you don't pay it, the landlord then has to actually use a form that was actually created by the court system to actually do a 10-day notice. So you didn't pay the rent, but I'm going to tell you 10 days from now, I'm going to file the eviction. So you do that 10 days. The tenant knows for 10 days that they've got to figure out to pay the rent, or there's going to be a document filed at the court system. Now what you're telling me is because the landlords have exercised their right to accept their rent and given everybody at least a 10-day notice of intent, and now you're saying that that's unfair to the tenant? I don't understand that.
I can take a first stab at it and I'll let my colleagues respond if they would like to. So the 10-day notice and the filing, those are unjudicated actions that the landlord could take, whether or not they are legitimate or not, right? So as my colleague said here.
Whoa. I
So-
don't necessarily agree with that, because if I'm going to get at a failure to pay rent, I have to prove that I gave the 10-day notice. I have to prove that it was actually posted on the door, or did I pay a third-party person? So it's not, I don't
Correct.
understand
Well,
that.
the legitimacy is whether or not the amount of money is owed or not if the 10-day notice was posted or not. Like my colleague said here, there are landlords that file and they're unlicensed, which is they are unable to receive a
That's a
judgment.
separate issue. The
Well,
unlicensed part is a separate issue.
well, it wouldn't be an issue in this matter because the result of that case would be a dismissal,
Okay,
right?
well, how many of the failure to pay rent are adjudicated because, and that's not the right word, I'm not an attorney, but are dismissed because it's actually, you don't have a license?
I mean, I couldn't tell you the numbers of that. Maybe legal aid has numbers behind that. I couldn't tell you the percentage. But
It would seem to me that if that's one of your leading reasons why we should be changing this in this particular bill, you would know what that number
it is
would
one of
be.
the reasons. However, there are many reasons why a case is dismissed, correct, right? Whether or not the court finds that the landlord has established the evidence, whether or not there is a defense. There are many ways that result in a dismissal. But the fact that there's a filing, the fact that there's a 10-day notice does not credibly create a record that needs to be solidified in amber forever, right? And so a dismissal would allow for that to be shielded. Now, the shielded does not mean that it's never be able to be accessed. It just limits the inspection of it for the purposes of shielding. So
Right.
And
So if I was a tenant and I did not want to pay my rent on time, and I knew that I got my 10-day notice, then I knew that I was going to be able to get an extension. Normally, it's going to be anywhere. I know that in Allegheny County, it's 7 days for me to get to either Wednesday or Friday when we do failure to pay rent court. So you're going to get 5 or 6 days there. And then through arbitration, when we go to the actual court case, I then pay the rent. The landlord who wants to actually keep a good tenant, or keep a tenant, regardless if they're good, bad, or indifferent, keep a tenant, and then the tenant does it time after time after time. Now, you're telling me that should be shielded from anybody else in the future because that tenant has actually demonstrated that they've gamed the system?
I think there's also a couple of safeguards you're ignoring for landlords in this matter. I think there's a couple of safeguards you're kind of ignoring in this matter for failure to pay rent cases. If it takes more than 5 days to schedule from the date of filing to the hearing date for a failure to pay rent case, a landlord can request on line 7 the future rent that comes due after filing before the hearing, which means that if the timeline's even marginally delayed, which most of the jurisdictions that I've practiced in, the delay between filing and the hearing is roughly what you just stated. And so it's a little bit in excess of those 5 days. That means that they're not filing it month after month. They can request that future month for that second month there, which means that you can have a December.
But we're already having issues with tenants not having the amount of money. There's another bill that the governor has put in that says you can't add 2 months of security deposit because people can't afford the rents of where they're at, and then adding 2 extra months for the security deposit to come up with that. So that to say that I now am going to have to collect next month's rent and adding it to it, that is putting a burden on the people who I believe you're trying to help. I mean, look, I know personally of this case, and we really have, for whatever reason, I tend to believe that the reason that the failure to pay rent cases are so high is because the state of Maryland has made it so hard for landlords to actually work with their tenants, to make sure that they can pay the rent. the bill that the governor's gonna be putting in, I've already talked to his legislative shop. I said, in Allegheny County, we actually work with those people who are on the fence from not being able to get housing. We use the energy assistance to actually use that to help people do a 2-month security deposit, because it's used as in the case of there's a time that they might not be able to pay, they can dip into that security deposit. So I tend to believe that while you're trying to help people to have housing security, the issue is not the landlords per se, and they're bad landlords, so I'm not blanketing them. But what you have done is you have hurt people who actually want to have a good relationship with their tenant and the landlord. And this is an example of it, that this shielding part, if the tenant is a good tenant and you have an application that does not pick one over the other, meaning like we should not be discriminating about source of income. Look, I was the sponsor in the House. Took a lot of heat for that, but I was a sponsor for the House. But we've got to stop beating so much on these landlords. You wonder why it's so expensive? It's because we keep on putting these regulations on these landlords, making it hard to divvy out between people who are actually on the edge of not being able to pay their rent, and the ability of those people that have used these vehicles to actually scam from not paying their rent. Last year, we had another bill in that a young lady stood here and the question was asked by Senator West. And it had to do with, was when the last time that you paid rent? She admitted it was 10 years. It was 10 years she hadn't paid rent. Now, the landlord probably was the biggest scumbag that ever walked the face of the earth. Okay? And I agree with that. But at some point, she's got to go find another place. And you can't tell me for 10 years she couldn't find another job. That court case ended up getting settled, and she was actually mentioned in it. So we've really got to stop demonizing landlords. Please don't throw out the baby with the bathwater.
And this legislation, I don't think demonizes the landlords. It's really about the collateral consequences of the filing of a failure to pay rent case.
Trust me.
The fact that
I don't want to file a failure to pay rent. I want to collect the rent. 75% of anybody that rents from me, 75% of people that actually get employed by me have some form of a criminal record. I am a second chance guy, but you make it so hard for legitimate landlords to actually be able to make any money. I'm not talking tons of money, but just make a little bit of it is just absolute. At some point, we have to be looking at the landlord. I apologize for going off, but this is very, very personal to me that I have tried, and I have other landlords. The landlords meet with the local HRDC on a monthly basis, trying to figure out what's the best way to make sure that the tenants can stay in their homes. The landlord doesn't want empty spots. They want to get paid. So I apologize.
And again, when I was talking about collateral consequences, and as my colleague already mentioned, that these are cases that the courts made no determination whatsoever. The underlying facts, we don't have information about why these cases were dismissed, because for the most part, the landlords don't provide that rationale. I can provide anecdotally the number of cases I had that were dismissed last year for a lack of licensure, which is substantial. Payment prior to trial is another substantial portion of them.
I don't think
The fact that a landlord doesn't want to litigate a rent escrow dispute in a failure to pay rent case is another reason why. And there's also plenty of other reasons why. It could also be a misplaced subsidy where your client, the landlord simply has not received the subsidy and is trying to prod it along in that way.
Right,
These are all reasons why these cases get dismissed, and there's no determination by the court or anyone as to why they are. But we know there's a lot of them, and there's no determination that anyone has done anything wrong in this case or has done anything in this case.
There is a determination. It's called the frequent flyer. If you've got somebody who has gotten from different landlord to different landlord, failure to pay rent, and then you don't have a name that shows up every single time, you do have a pattern there.
And to address that, there is a frequent flyer, use your terminology, exception inside of this bill. So inside of failure to pay rent cases, in Baltimore City, it's 4 cases. In Baltimore, in the rest of the state, it's 3 cases. There's 3 prior judgments within a year. The landlord can foreclose a right of redemption. This bill actually, which means that even if you pay after the judgment, you get evicted either way, or your landlord can proceed with the eviction either way. There's an exception for people that have received, or for the cases that have been finalized as a no right of redemption, that they are not sealed or shielded. I'm sorry, shielded. Those cases are not shielded under this bill, which means that for the frequent flyer you're talking about, those frequent flyers would still be discoverable. And in those cases, those are ones where the courts made multiple determinations that rent was due, and they've had plenty of opportunities to do so. And those are the cases where I think the landlord is still protected from the frequent flyers that we know about under the shielding statute, because they would not be addressed in the statute or in this bill.
Well, you've polished it, and there's a little bit of a shiny star, and I appreciate that part.
Thank you.
Thank you. Good call. Good,
Respond to
good.
that.
Thank you, Senator McKay. All right, so who was first? Was it Senator James, and then Senator West? Yep, Senator James.
Thank you. I think Senator McKay brought up a number of the issues I wanted to. I am a mom and pop landlord myself. So I know one thing is very true, at least of mom and pops, of the vast majority of people, but I realize there is an exceptional group of people that are not good landlords. We just want the rent on time. And we want the rent on time, or within a reasonable, I work with people, but a reasonable amount of time, because for every story you tell me, and I get it, about, a bad situation for a tenant, there are lots and lots and lots of mom and pop landlords who cannot pay other bills until they get the rent. It happens all the time. Unfortunately, we don't have a mom and pop landlord association. If we did, we would have a balanced hearing here. I feel like we're taking a sledgehammer to kill a gnat. I hear the problem, and I really am glad Senator Senior is bringing this to our attention. And I think it's been in other prior sessions, but I feel like this is not the ideal solution. It's a quick solution, and it's a one size fits all. And I don't think there's been a balance between the good and the harm. And that's what I think we're here for, to balance the good and the harm. But I will tell you, as a landlord, I don't want to be deprived information. I don't want to have things shielded from me. Knowledge is power for everyone. I would be delighted if there be more information on a court record about the case's disposition. I'm happy to support a bill that says tenants can put on there a statement as to what happened. So I explain, because I have taken plenty of tenants that have had a history of not always being able to pay on time. And I let them go a lot myself. So I get circumstances come up all the time. That's not going to keep us from renting to somebody, because we know life happens, especially if, generally speaking, you're trying to pay, you catch up. But what I don't want is for me to be told I'm making a business decision and I'm trying to find good people. And it's not just their record, but that is an element. And then it's talking to them. So I just don't think you've come in with a balanced approach. And I'm going to say this. I get what that Baltimore City and maybe some other areas have enormous problems of a different nature, but we are talking about a statewide bill. I'd be happy if you want to keep it to Baltimore City. So again, I think that you have the burden of proof. You're moving the bill. I don't want anecdotes. I want data. I want data that says that your situation cannot be resolved in any other way other than this. That's, I want to know that you've just given me 2 weirdly freakish, and I get it, that they were terrible situations and they were not right and it wasn't fair to the tenant, right? And unlicensed landlords. That seems like a real bad problem. But to me, there should be a lot of data on that what's going on and the balance that's being struck and whether or not, and that data would tell me if you struck the right balance. But right now, I don't feel that you've struck the right balance because you're keeping me from we've talked about shielding in certain circumstances, because we don't want something over here to impact you over there. We don't want a really old criminal record to keep you enslaved, really, from getting an education and getting a job. But you are asking to shield the very information on the very topic that I need to know about. But I'm happy if we try to figure out a better way to provide information so then when I look online, I can see some additional information. But again, no landlord that I know, and I think most people are decent, and I'm sure there's a percentage that are not, and I don't know, that's 1 or 10. We just want to get paid. And I think there are a lot of opportunities for tenants to get landlords to get paid before they go to court. So I'm hoping we can talk later about this because it's late.
Yes, but to address a couple of things. First off, I can understand the plight of the small time landlord. I'm a mom and pop landlord myself on a personal basis. So I understand exactly where you're coming from. And your second point of burden of proof. That's what this is about. Burden of proof. There's no adjudication in these dismissals. The courts determined absolutely nothing. For all we know, these cases were the landlord wrote the wrong name on the case. We don't have any way to know that.
That's
we're saying
what I just said.
No
I want more information, and I'm happy to do a bill that'll allow that to be put online.
But functionally, the court doesn't make that determination at all at a dismissal. The case is
I don't
voluntarily
need a court
dismissed.
to do
and
it. I
that's
would
the
let
end
a
of that
tenant do
determination.
it. I'm sorry, I don't mean to be sharp, but I don't want to debate things that you did. I'm sure I wasn't clear, but I'm not saying the court has to do this. I'm happy to come up with a mechanism to let the tenant put information online about what happened, right? It doesn't have to be a court, it's something, but I don't think shielding completely. So if the tenant says, my check burned up, the million reasons that things happen. And then if the landlord wants to say something else, that's fine too. But what I don't want is complete shielding in a blanket. I don't think a blanket approach solves a important, very important, but smaller percentage problem. And I'd like to think about how we can get to fix that problem. Thank you.
Thank you, Mr. Chair. And I just have a couple of questions. I'm focusing on the language in the bill that says a landlord may not increase a tenant's rent solely because a judgment was entered against the tenant in a failure to pay rent action. So how in the world is anyone going to get inside the landlord's mind and make a determination that the reason why the rent was increased was solely because a judgment was entered against the tenant previously? 3 months, 6 months, 18 months previously. How do you get inside the landlord's mind and make that determination?
In cases like that, the landlord would explicitly state in their notice that they're increasing the rent for the purposes of I filed because of,
But if this bill is passed, what landlord in his right mind is going to put that admission?
They wouldn't.
They would?
They wouldn't.
Okay, so my second half of this question is, if there has been a judgment entered against the tenant in one of these cases, and 3 months, 6 months, 18 months later, the landlord increases the tenant's rent, does the passage of this bill entitle the tenant to file a lawsuit against the landlord for violating this bill and to seek damages against the landlord for violating the bill?
In my conversations with Delegate Hill, that's never come up as the intent of this bill or of any sort. That's never been a part of the purview of this bill at all.
Would you be opposed to language being inserted in the bill that specifically says that this language would not authorize a lawsuit to be filed against the landlord by a tenant arguing that the rent increase was solely because of a prior judgment against the tenant?
As a representative for the Public Justice Center, no, we wouldn't oppose that kind of language.
Does the sponsor of the bill, would you accept such an amendment?
Go back.
Okay, thank you.
On behalf of legal aid, we're requesting that this bill move forward with a favorable recommendation without any amendments. But again, I think the issue, as we've addressed here, the intention is not to make it an extremely large avenue to proceed, but a court would need to make that determination. And the only way the court to be able to make the determination as is presented in this bill, I think would need to be literally the smoking gun, where the landlord flat out said, I'm raising your rent in the notice to renew, saying I'm increasing your rent because I had to file a bunch of failed to pay rent cases against you.
Well, let me just, if I could follow up just with one last question. So why don't we just take that provision out of here? Since no landlord is going to be dumb enough to say that I'm increasing your rent solely because I got a judgment against you. And that would eliminate the concern that tenants would use this as an excuse to file lawsuits against their landlords.
And you would vote for the bill, right? If I do that?
What's that?
Would you vote for the bill if I do that?
I'd at least consider voting for the bill. I'd be more likely to do it than I am right now.
All right, I'll certainly take that under consideration. I'll talk with our cross file about that. Thank you.
So hopefully we can all agree that a coin has three sides. There's the front side, the opposite side, and the rear edge of a coin. So look, Senator, I am a horrible poker player. What you get is what I say is what you get. Good, bad, or indifferent.
Yes, sir.
I literally don't have a problem for me to say to my tenant, who I have over, let's say, 4 times, 6 times had to take them for failure to rent, that said that I am going to increase your rent by the cost court that I couldn't collect. That is an actual cost of doing business with that particular person. You follow what I'm saying? I don't want to raise the rent because the utilities are up. I don't want to raise the rent because my taxes are up, whatever the case may be. For that particular person, because of situations that may or may not be beyond their control, to rent to that person, it's going to cost X amount of dollars. That's not coming from somebody who doesn't want to rent to that person, but takes into consideration that those are the expenses. So please don't take that, and I know it's tongue in cheek, that a landlord is not going to admit to something like that. If they're honest, they are going to admit to that, to say that it cost X amount. I'm not talking if it's $100 and you're going to raise it $500, that is certainly out of bounds. So I just don't.
I heard Senator West, and I will make certain that I'll take that to Delegate Hill. I hear you all.
Thank you.
I don't think the bill text already reflects this to some degree, because the bill text, I think, uses the word arbitrarily. And I believe in the situation you're explaining, it's not an arbitrary increase if it's the actual cost of doing business. So if you need to raise the rent for $50 because you're spending $50 a month to file a failure to pay rent every month, then that's not an arbitrary increase.
Okay. Thank you.
All right, more questions from the committee.
Mr. Chair, you've missed a grilling of me today.
I know, hey, it felt like caucus this morning for me. Hey, it felt like Senate caucus for me this morning. Just for Public Justice Center, though, I thought one of the comments you made with the Senator West proposed amendment was instructive and will be instructive for some forthcoming legislation that deals with the pass-through. And so, just put a pin in that for now, but I think we should continue talking because that was interesting to me, at least. Yeah. Okay. Seeing no further questions, that'll conclude the testimony for the proponents of the bill. Thank you, Senator Sidnor. You're off the hot seat. Now we'll move to be favorable with amendments. Ms. Howard, are you coming up? Come on up.
I think.
And then who else?
Did you miss
John Quacko. Yeah. Oh, sorry. You're favorable.
Yes.
Sorry. Let's go ahead and take the last favorable, and then we'll go to Ms. Howard.
Be quick.
Thank you, sir.
Good evening, I believe by now, Chair Smith and committee members. My name is John Kowalko. I'm a staff attorney for the Anne Arundel Eviction Prevention Legal Program, which is part of Community Legal Services of Prince George's County. At CLS, it's a private nonprofit organization that has provided free legal services to low-income Maryland residents. Each year, CLS assists thousands of tenants who are facing possible eviction, with the vast majority ultimately staying in their home. Maryland has the highest eviction filing rate in the nation. It is 6 times the national average and twice the closest next state. Many landlords unfortunately use eviction filings as an initial course of action, and these proceedings create a permanent public record that significantly impacts the ability of tenants to find future housing. However, the vast majority of these cases do not result in an eviction. 1/3 of these cases do not even result in a judgment. Only 5% of tenants who have an eviction filing are actually evicted. The rest are able to pay their late rent or should never have been brought to court in the first place. As a result of this over-reliance on the eviction process, over 100,000 failure to pay rent proceedings are dismissed each year in this state. These filings have a disproportionate impact on Black families, women, and low-income households, and children are the most likely age group to be impacted by these evictions. CLS supports the changes under SB 19. There are many reasons why tenants may fall behind on rent and have to pay their rent late. However, tenants who pay rent late should not be punished with a permanent public record for which relief is either overly burdensome or impossible. SB 19 would create mechanisms to resolve these concerns. And in particular, it should note that individuals who receive a judgment would have to wait at least 12 months to get that judgment removed from public records. So any future landlords in that 12 months would have notice of those previous filings. CLS urges a favorable report on Senate Bill 19. Thank you for your time.
All right, thank you very much.
Thank you.
Apologies for that small oversight there. Ms. Howard, you're up.
Thank you. Kathy Howard, General Counsel for Regional Management, Inc., here testifying favorable with amendments on this bill. I think that as the hour grows late, and I understand that there are things we still need to do, I'm just going to say that I think all of this discussion tonight indicates that perhaps we need to work a little bit more on this bill. We understand what the concept is here. We worked with the sponsor last year, and we are still willing to work on this bill to try to make it something that people would be interested in actually voting for. No questions.
No questions. All right. With that, that'll conclude the hearing for Senate Bill 19. Thank you very much, Senator Sidnor. We'll now move to our final bill of the day, Senator Waldstreicher with Senate Bill 162. Mr. Vice Chair, if you'd like to bring up your panel.
Yes, please.
Thank you, Mr. Chairman, members of the committee. Under current law, a person with a disability is allowed to terminate a lease under certain circumstances with the certification of a physician. That's a good thing, and I strongly support current law. But there are 2 issues with current law. First, current law appears to contemplate only physical disabilities when we know that mental and intellectual disabilities may require care that necessitates termination. Second, while physical disabilities are often certified by physicians like an orthopedist or a neurologist, mental disabilities rely heavily on licensed, expertly trained, highly credentialed professionals who are not medical doctors. Psychologists or licensed therapists are the best example of this. The bill in front of you closes both of those gaps. It explicitly creates policy parity between physical and mental disabilities, and it clearly allows therapists and psychologists to certify mental disabilities in the same way that physicians can certify physical disabilities. There may be some refinement necessary as to the wording that creates a nexus between the mental disability and the need to terminate. You'll hear from our friends at MMHA on that necessary refinement. MMHA, are working closely and productively with the House sponsor to get that wording just right. I support those efforts and will draft that amendment for your consideration once it is ready. At that point, Mr. Chairman, I will ask for a favorable report.
Good afternoon again. Albert Turner of the Public Justice Center. In favorable review, asking for a favorable report for Senate Bill 162. We acknowledge the Vice Chair's a great bill when it comes to enclosing the gap that mental disabilities have gone unprotected in this realm of least liability. If I can give you a story a colleague had dealt with, where a tenant was a student at the University of Maryland, and she suffered from a debilitating mental disability that required her to have to move back home. Her family, her father, tried to negotiate with the landlord in order to let them know about the issues that she's been dealing with, that the mental disability, relegated her to not being able to live under her lease as currently constructed. But without the protection of Senate Bill 162, she was unable to negotiate a lesser amount to be due. What this bill would do would extend the protection that is already afforded to those with physical disabilities, to those who have mental disabilities, to be able to limit the amount of rent that would be required under their current lease, acknowledging the fact that people have these debilitating disabilities at a whim, that they are not just they come out of the blue at times, and it acknowledges that and when those things happen, people need to be able to have their rent liability limited for that. And because of that, we would request a favorable review of Senate Bill 162. We haven't taken a look at the amendments, but once we do that, we'll probably be in line with that as well. Thank you very much.
Good evening, Chair, Vice Chair, and distinguished members of this committee. My name is Morgan Mills, here today on behalf of the National Alliance on Mental Illness Maryland, or NAMI Maryland, representing a network of over 58,000 people across the state. You have our written testimony, but today I want to share the story of a NAMI member who lived in Howard County. She writes, "I battled with major depressive and generalized anxiety disorders that altered the course of my existence. Eventually, I received a bipolar disorder diagnosis. Upon receiving this diagnosis, I attempted to end my life, and my mental health quickly declined. I found myself incapacitated, unable to maintain gainful employment. The toll on my mental health was such that I became unemployed, creating a cascade of challenges related to my financial responsibilities. Basic daily living activities became monumental hurdles. Simple tasks like personal hygiene, cooking, and taking care of myself became increasingly difficult. The struggle extended beyond the mental and emotional realm and manifested in tangible ways. One of the most significant challenges was the necessity to vacate my apartment. Despite presenting documentation of my diagnosis to the leasing department, I was required to continue paying rent until the end of my lease, even though I was no longer residing on the premises. This added financial strain exacerbated an already difficult situation. I had no choice but to seek refuge with my family, as living independently was no longer feasible. The journey has been challenging, marked by moments of despair and uncertainty. I'd like to note that someone's access to housing can affect and in turn is affected by their mental health, and mental illness can develop or worsen at any time. So it's only just that the law offers those with mental illness the same protections it does for those with physical ailments and impairments as it pertains to being liable for rent should they need to vacate due to their illness. We ask for a favorable report and thank you.
Thank you very much. Questions from the committee? Senator McKay.
Hello.
Hey, I get somebody, unfortunately, they're in this condition that physician is signed off. Is this just to let them out of their lease? Meaning if they've been there for January and February and I'm getting this in February, are they still responsible to pay January and February? Or is this just letting them out of the rest of their lease?
So my understanding as to current law with regards to physical disabilities is that it is only forward-looking. It is not backwards-looking.
So this would be continued, would mirror
Correct. So
that?
this would apply current law to intellectual and emotional disabilities, but would not change it to be backward-looking. In other
Okay.
words, if you still owe rent for previous months in which you legally were required to pay and didn't pay it, you still owe that money. This bill doesn't change that.
Okay. Where's Senator Senor? Oh, I was just gonna tell him I found one I could vote for.
Thank you.
Yeah, just a super quick question. Thank you for bringing the bill. And I believe in the parity between mental and physical. In fact, it's an oxymoron to say it because your brain is your body.
Right,
Okay,
that's exactly right.
so in a way, you could almost fine tune it so that we just do that in this simple bill, right? As opposed to trying to separate them. But I didn't quite follow. I'm sure that you had a thought in mind, but I didn't understand sort of the sudden onset of an intellectual disability unless there had been quite an injury perhaps to somebody, you know, when they suddenly did have a cognitive impairment. So I'm a little confused on that section, the intellectual
Sure.
disability.
So if it's okay with you, Senator, and it's okay with the chair, I think the NAMI
think,
representative is
yeah.
best positioned to answer that question.
I don't need a long answer. I just wanted to just make sure I understood that.
Sure thing. So mental illness, as I mentioned, can be onset at any time. And as far as intellectual disabilities go, as you alluded to, there are freak accidents where someone does have a cognitive impairment that is unexpected. And so I would say you answered your own question in that case. Is that
right? So that's what I was thinking, but I thought, which to me, you do not need to segment it out. You just need to clarify the physical, because honestly, sure, whether it was, God forbid, a stroke or a brain hemorrhage, which could cause, that is still a physical or a terrible accident. But the way it's drafted, you want to know how a stranger to the bill might read it, which I don't want there to be confusion, is suddenly there's a sudden onset intellectual disability, which I don't think normally happens. Either, unfortunately, you're born and there's genetic and other things, or there is a catastrophic something that happens that is clearly biologically and physically based. So just a suggestion that I think we could make that language a little bit better and less like my reaction. And I'm someone who's very well versed in this area and was thrown off by that, right? That's all. Thank you.
Absolutely. I'm happy to work with you on that. Thank you.
Awesome. Seeing no further questions from the committee, thank you, Mr. Vice Chair, and thank you both. I think we're done. Are there any other witnesses wishing to testify? Everyone's gone.
For favorable.
Favorable?
Yeah, we've got 3 left.
Okay, Ms. Howard, if you'd like to come on up. And Mr. Greenfield, and then we'll hear from Mr. Washington.
So you can collect yourself?
Yeah.
Okay. Good evening, Mr. Chair, Mr. Vice Chair, members of the committee. Aaron Greenfield here again on behalf of the Maryland Multi-Housing Association. We certainly Senate Bill 162, we're favorable with amendments. Really appreciate the time the sponsor has taken to listen to our concerns. You have our written testimony. I'll be super brief. We think the current law actually works really well with the physician diagnosing this. And actually, we think that a physician could diagnose a mental disorder or disability now. And in fact, you might hear from Ms. Howard where she's accepted such a diagnosis from a physician. So, we have some concerns about expanding the pool to other healthcare providers and creating a new standard. So we have some concerns about that, and that's listed in our written testimony. Particularly the term substantially limited by the lease premises is unclear to us. We have our own suggested standard in our testimony. We would like the healthcare provider, particularly the physician, to be domiciled in the state, because we think they should be able to go and look at the leased premises if they're going to make that kind of a diagnosis. And we think this, again, should only be limited to physician or psychiatrists. And for those reasons, we look forward to continuing to work with the sponsor and getting to a good place. And we're favorable with those amendments. Thank you.
Following up on that, yes, in the testimony that we presented to the committee for Regional Management Inc., we have oftentimes had exactly these kinds of problems with some sort of mental illness or mental breakdown of our tenants. All we really we do have an escape clause, if you want, in our leases, but that escape clause is generally speaking a 60-day period, and a lot of times these things are much more much more concerning than giving up that 60-day period. We do rely on the information we get from a treating physician or a therapist. But we are concerned that we don't want that universe of providers to be too large, and they have to be licensed in Maryland. And it is very important to us that we know that we can rely on that information to end a lease under these circumstances. I think we do have some very good amendments that we are working on with the sponsor, and we'll continue to do that. Thank you.
Thank you, Mr. Chairman. I know initially I had opposed, but I've had conversations with the House sponsor, and we are working on making the bill more amendable. I'd just like to highlight that ditto with MMHA and Kathy's testimony. I'd just also like to just expand on the point that this bill does create new conditions for counselor and therapists, and which we appreciate, but we just have to be very careful in our assessments in terms of how we determine the grounds for breaking a lease. I understand the bill does allow for a counselor and therapist to be certified in the state. However, counselors have a master's degree, and they can diagnose but don't prescribe medicine. So one of our asks would be to expand that to include a notice or verification from both a psychologist that can prescribe and a counselor, as there are cases where it can be subjective. If you have depression, where you could be medicated and your overall mental health can improve, well, then that couldn't be a grounds for breaking a lease. However, there are some aggressive and more serious cases of depression where you can't live on your own or have to be hospitalized, and that's such. So there just needs to be more clarification and conversations around that. But overall, we support the intent and are willing to work with the bill sponsor. Thank you.
That's great to hear. All right, questions from the committee? Seeing none, that will conclude the hearing for Senate Bill 162 and our hearings for the day. Have a good evening, everyone.